Morning. Underway with hearing stream 11, the Wellington District Plan. For anyone around on air, my name's Trevor Robinson. I'm accompanied by Commissioners Burge, Pomare and Daish. The subject of this hearing is Indigenous biodiversity, both in the Eco chapter and the Eco Infrastructure Eco subchapter. We have some procedural issues we need to address. The first is Mr. Whittington. I'm not sure if you're aware, we had a communication from Forest and Bird last week. Their legal submissions would be late. Excuse me, the lady in the back, are you from Forest and Bird? Oh, Lisa Hayes, sort of in the background. No, jump ship. Not present. My request, the information didn't say when we would be favoured by Forest and Bird's legal submissions, since they haven't provided any planning evidence, but do have a very extensive set of submission relief on this topic. I'm anticipating that the legal submissions will be in lieu of planning evidence, and 80% of them will look like planning evidence. So this caused me considerable concern. I told the message I asked a hearing administrator to pass back was, if the submissions weren't in hand by midnight on Thursday, I'd expect an application which addressed the prejudice to the council and indeed to the panel of their being late to accompany them. The message was acknowledged, but since then we've had radio silence, so we have no idea when Forest and Bird will favour us with their legal submissions.
Actually was in his very the lack of technical, so I was surprised the permissions, and when I logged on and see that only was due for a while. What approach
Well,
procedural.
Well, I think I had hoped that, well, I'd certainly assumed we would have them by now and we would be able to consider Forest and Bird's application right now. But in the absence of either an application, submissions, or a representative of Forest and Bird, I think we can take the matter no further. I think at this point, clearly there's a problem, but we'll have to see what we can do about it when they surface.
There's no
Yeah.
for you to
Exactly.
Procedural description submission and or see what they ask for.
Well, that's right. So I think that this is it is what it is. We'll address it when we have something to address. We also had a request from Greater Wellington that they might provide their hearing statement. Past experience would indicate that this will be in the nature of a policy statement, not a legal statement, a statement from the Regional Council's policy and people. I consulted Mr. McCutcheon, who was relaxed about getting it, and I made a verbal direction that it would be received if it was in hand by 4 o'clock today. Now, I think that that's the only procedural issues around, unless you have something you need to raise with us. Well, that was going to be my next question. How are you going to run this show, given that we've allocated 2 days to the council team, or the best part thereof? I think we'll need quite a lot of that. There's a lot of detail in the material, and we'll see what. I'm sure we'll have an interesting discussion. Mr. McCutcheon, do you want to, is your plan that you'll go first and give us an intro?
Correct. Thank you, Chair. So how I thought we would run this morning's session would be I'll introduce myself. I haven't met some of you before, so it's a pleasure to do so. We'll then hand over to Mr. Whittington to talk to his legal submission for the council, and then to Mr. Norman, who sits to my left. He is available to yourselves to ask question of his economic evidence. So I'll start. I don't have a big long spiel to start with, other than pressing home on some points from the executive summary of my 42A report that I wish to comment on at this stage.
Well, I'm glad you don't have a big spiel, given the 240 odd pages of 42A report.
Yeah. That was my view as well, that I've had enough time to say all the things that I really wanted to say.
Yep.
But kia ora koutou. So my name is Adam McCutcheon. I'm a team leader in the district planning team at Wellington City Council. Joined here on my left by Mr. David Norman, principal economist at GHD, and on my right, Mr. Nick Whittington, to whom you are familiar. Tomorrow we'll be joined by Mr. Nick Goldwater of Wildlands Ecologists. He's a principal ecologist at that firm and has provided some advice to me to support me in this process. For clarity, I note that I continue to abide by the Environment Court Code of Conduct for expert witnesses in my evidence that I provide at this hearing. So to summarise, this has been quite a challenging 42A report to write. I think that is a result of a highly directive national policy statement for Indigenous biodiversity, seemingly shifting legislative sands of RMA changes making its way through the House, looking to suspend requirements for Indigenous biodiversity, requirements to create well-functioning urban environments under the National Policy Statement on Urban Development 2020, which continue to apply for this council, a very general New Zealand coastal policy statement, and changing directions under the regional policy statement as well, which the Regional Council and in their evidence, I hope, will speak to the approach that they have taken to reconcile the NPSIB in that process. A large part of my time in my Section 42A report was spent trying to reconcile all these conflicting directions and come up with a sensible and perhaps logical approach to implementing the NPSIB now, as well as responding to the very real concerns of submitters in this process. In doing so, I found that there were some provisions which I did feel confident we could pursue an approach of trying to align this district plan with at this point in time, whereas others perhaps needed to be deferred and in a more fulsome plan change process followed to implement those directions. Accordingly, I have recommended some pretty significant changes to provisions and some departures from the notified ecosystems and Indigenous biodiversity chapter. These were to reconcile these tensions between the NPSUD and IB, which unhelpfully have not been resolved at a national level, as well as to respond to the concerns of submitters. In terms of the key resource management issues, I consider these to be the principle of SNAs in principle and their impacts on property rights, how the NPSIB should be implemented, and accordingly the tightening up of the rule framework, which I have proposed in response to that document, and how Indigenous biodiversity outside of significant natural areas should be managed. On that matter, I think where the crux of the issue now lies is whether achieving objective 1 of the NPSIB, the maintenance of Indigenous biodiversity so that there be no overall loss, as is defined by clause 1.7 of the NPS, can be achieved through the provisions that are confirmed in the plan, irrespective of any move to codify an outside SNA approach, as well as through restoration and regeneration, which will occur over time. The data is pretty patchy. The Wildlands report, which was provided to support this process, shows that yes, perhaps some forms of Indigenous biodiversity will be able to be maintained, and trends are looking positive through restoration and regeneration that has been occurring in absence of any regulatory framework. the regional council state of the environment monitoring reports, perhaps not so much, and a bit more pitched at a regional level, so it's hard to discern what those trends are for Wellington City. Clearly, some parts of the natural environment are doing great and going gangbusters. We've never seen so many kaka flying around the city, but in other forms and other types of Indigenous biodiversity and the attributes by which are assessed, perhaps not so much. I'm not entirely sure based on the evidence that's out there. I really hope that we could use this hearing process to flesh out this very question, and that submitters who have put forward controls to manage Indigenous biodiversity outside SNAs would be able to present some commentary and some evidence by which we could have a good discussion around the proposed outside SNA control and whether it is indeed warranted and needed in light of the regeneration and restoration that's already underway. I'm still hopeful that that will be the case, and we will receive stuff over the course of this process through which we can turn our mind to. I think in short, the proposition that I have made through my rebuttal is that if the answer is yes, if biodiversity can be maintained, so there's no overall loss per clause 1.7, in absence of any outside SNA controls, then they probably aren't needed. But if the evidence is not there and the data cannot be provided by those submitters, the precautionary approach kind of compels us to take a different direction, and that's also at the forefront of my mind. So on that sort of precipice of potential different directions, that is my introduction and opening statement. And I'd like to hand over to Mr. Whittington, if that's okay, to start his legal submissions.
We'll leave your intro as an intro and deal with the detail as when you come to your turn, Mr. McCutcheon. So, Mr. Whittington.
Thank you. A little like Mr. McCutcheon, I haven't prepared anything particular to talk to you about. Partly that's because the nature of my submissions was to really highlight some things that actually I think are, in a sense, irrelevant. I'm thinking in particular of the new legislation, which is on the horizon but doesn't really affect the decision making that you have. I've noted a sort of an interpretive difficulty that I found with it. I don't know whether you take the same view of it, but it's not one that you have to resolve by any stretch. I just pointed it out in case it was one that other submitters wanted to somehow argue might affect you or might affect the council's decision making when they come to consider recommendations on your or the recommendations that you make. Other than that, I didn't really have anything to add, so I'm happy to answer any questions that you have. I don't envy the job that you have trying to really have the first crack at implementing this NPSIB, doing so having really done the work of implementing the NPSUD and having to work out how they intersect and where the work is done. I was reading again King Salmon and the East-West Link decision last night and looking for clues in the NPSIB as to the sort of hooks by which reconciliation can occur, and there are lots of sort of where practicables and inappropriate, similar to King Salmon, where inappropriate was said by the Supreme Court to do the work of enabling the reconciliation to occur. But that's going to be a matter, I think, for the real detail as you get into that with Mr. McCutcheon. So happily I can say nothing more about that, hopefully.
Well, I do have some questions about your written submissions, Mr. Whittington, and I think that some of them are more the flag issues for Mr. McCutcheon to think about before I ask him the same question.
I'm sure that'll be helpful to him.
Particularly, I suspect your answers might be more helpful to him. The first question is something that relates to your paragraph 2.7. and the effects framework in the NPSIB, which is, I haven't put them side by side, but my understanding is that it's identical to the effects framework in the NPSFM. In something that's puzzled me ever since the gazettal of the current NPSFM.
Mm.
So if you look at this and you go, all right, fine, avoided where practical. Where you can't avoid, minimise where practical. Then where adverse effects cannot be minimised. And that's the thing that intrigues me.
Mm.
How can adverse effects ever not be minimised, since minimised is to do what you can do?
Mm.
It doesn't seem to make sense. But so tell me what the answer is. How do you ever get past B in the effects framework?
I think it depends on the definition of minimised, or how you approach the word minimised. And I say that because while I thought that it was reasonably clear, I was having a discussion with someone a week or so ago, and they were questioning whether the word minimised includes does it just mean merely reduce, or does it mean sort of reduce to the lowest available or practicable level? And my view is it's clearly more than just reduce, otherwise they would have used the word reduced. It's got to be,
or mitigate.
Yeah, or mitigate, that's right. So it's got to be reduced down to the lowest practicable or available level of that particular type of effect. And so, you know, if it has that meaning, either adverse effects can be minimised or they can't. And if they can't, well, then you move on to the next
Well,
step.
how can they ever not be minimised? If minimised is to reduce as far as you can.
Well, probably if you include practicable in there, as I just was, you can't. There's a practicable, something you can do in a practicable way, and if you can't do it, well, then you go beyond it.
That's sort of like internally contradictory.
Mm.
If it's practicable, it can be done.
That's right.
And so even if you, and the other potential meaning of minimise is minimise as far as possible, and and again, but again, that is something that can be done.
Yes.
So do you end up having to read minimise as meaning something other than the dictionary meaning? Because clearly your interpretation is the dictionary meaning. It's not just reduce, it's reduce to as far as you can, which like just produces to me a fundamental hole in this whole direction. Like you get to you always get to point B and you stop there. You never go any further. You never need to go any further.
It's also the added complication. We've got a definition in the plan already of what minimise is, and there was an issue in several of the hearing streams about what exactly does this mean. And I certainly know with the NRP process that was in debate as well.
Yes.
And they came up with a very similar definition which exists presently. So presumably when we're looking at minimise in the context of the plan, we're using that definition.
Well, that's right. And actually taking a step back, you sort of wonder whether it, I mean, when it's used in these two NPSs, it's clearly intended to have the same meaning. So to have different local authorities around the country coming up with their own definitions of minimise, it seems a bit odd to me. I don't think that's an example of each council coming up with a definition that's fit for its local conditions. It seems to me a show of flaw in the NPS that they haven't got a specific definition.
So do you have to read that as reduce in order to make sense of it?
Well, I
Is
I
that
can
the-
certainly
is that-
see
is
your
that where
argument.
you get to?
Yeah. What I was going to say is that if you go on to D, it says where more than minor residual adverse effects cannot be avoided, minimized, or remedied. So working in reverse, it seems to be suggesting that you start with avoid, you then try minimize, and then you try remedy. But if having done all that, you still have minor residual adverse effects, then you move on. So you can perhaps reverse engineer that by minimize, it means to try to create something less than minor residual adverse effects.
So basically, if the end result is more than minor residual effects,
Yes,
you move on.
you move on. But I mean, there's also, I think how you describe the whole, and I agree with you that it seems to me logical that it clearly exists. Partly it might be because of the inclusion of where practicable in all three, A, B, and C. Because if it was to avoid where practicable, and if not, you move on, then it's asking you to make a judgment call in the circumstances about what is practicable. You then move on to the next one. But at some point, you've got to stop making judgment calls about what's practicable or not and just do something
And assess the end result.
and assess the end result.
Say,
That's right.
is it acceptable or isn't it?
That's right. So it may well be that that where practicable in C is the problem, and you almost need to read it as if it wasn't there.
Yeah.
So you avoid where practicable. If you can't, you minimize where practicable, and if not, if you can't minimize, you remedy. And if you can't do that, then if after remedying or taking steps to remedy, you still have minor residual adverse effects, then you move on to offsetting and compensation.
Okay, go on. And your next section, the relationship between the NPSUD and the NPSIB, and this is obviously a theme that Mr. McCutcheon develops extensively, because this is really at the heart of how far do we push down this track and potentially erode the development capacity of the urban environment. We've said that the NPSUD contains strongly directive national policy, which is clearly correct. But the proposition I wanted to put to you was that on the face of it, the NPSIB contains equally directive, strongly directive you must identify SNAs, you must protect the contents of SNAs, you must maintain your biodiversity outside SNAs.
That's right.
And it's sort of like a resistible force meets a movable object.
Well, that's right. I think to some extent, and I mentioned this in 2.9, the council's decision not to impose SNAs on residentially zoned land postpones for the future the real clash between those two policy statements, because and there is, you would say, an ability or a point of reconciliation through qualifying matters. So if in a residentially zoned area where the MDRS is either, well, where the MDRS is applying now, if there is evidence of a significant natural area and the council through a plan change notifies that area, it will have to support and does so in a way that sort of either affects the zoning or proposes a set of provisions that conflict with the NPSUD mandated provisions, then you will have to go through a qualifying matter assessment in order to justify that, where a site-by-site analysis can be done comparing the benefits of protecting the SNA versus the national significance of urban development and the effect on the capacity of urban of dwellings that are otherwise included in the plan.
Is the at least in relation to qualifying matter issue, you're right, that is an avenue, and on the face of it, the application of the NPSIB to an identified SNA sterilises the land for residential development. And it's like a hazard overlay.
Yeah.
That would be like a flood hazard overlay would be the closest equivalent, but except that if it's an SNA, there's less room for movement than you would have with a hazard.
That's right.
And less room for judgment. Is the point where qualifying matter would be triggered where more than 50% of the site is identified as an SNA, because that would constrain the site capacity. Like in the practical constraint would arise earlier than 50%, but the legal constraint would be at 50%.
That's right.
But
makes sense to me.
But so the qualifying matter might be something less than 50%, but it's certainly when you get to 50%.
Exactly.
And so for instance, the property that Mr. Edmonds has made representations about on the Riggy, which looks to my eye about 90% bush, which is not an SNA at the moment.
No.
But if it were, that would clearly be a qualifying matter.
That's right.
And have to be considered as such.
I think that's right. And then you also get into actually quite difficult questions potentially with an example like that, where if it's an urban site and it's residentially zoned, you either need to change the zoning, or you're looking at Section 85 issues of reasonable use.
Well, if you change the zoning, well, the only other play would be a natural open space zone, and applying that to a private land would certainly
That's right.
Raise Section 85 issues.
Yeah. But even if you're keeping the residential zoning, if only 10% of the site is available for a dwelling, you're also potentially over constraining the site unreasonably.
That's right, and which is why there is a provision in the NPSIB for one lot of one residential unit in an existing lot as at the trigger date.
Yeah.
Provided you apply the effects framework. The trouble it seems to me with the effects framework is that if you're the owner of a single residential block of land, you have no capacity to offset.
No.
Because you can't go somewhere else.
No.
It's just not going to work in practice.
That's right. And then you're looking at compensation, and it seems terribly unfair, I have to say.
Well, like, who's compensating who? Is that point? So you go down these rabbit holes where things that seem to be provided by the NPS also don't seem to work in practice.
Yes.
To what extent, and I think Mr. McCutcheon touched on, to what extent was the application of the NPSIB in urban environments considered as part of the evaluation of the NPSIB at all?
Well, as I also hinted at, to the extent that it has been considered, I'm not sure that it was considered well or deeply enough, because there are a number of what appear to be sensible statements, but when you sort of peek beneath the surface, they're actually quite they're almost sort of throwaway comments. They don't really apply. So, for example, in the passage from the report on submissions, which I set out in paragraph 2.12 of my submissions, you read that and think, oh well, they're aware of the issue and they've indicated how it's supposed to work. But when you read the sentences, they don't actually make sense. They conflict, and so there's the appearance of having considered it, but I do question whether it's been a sufficient consideration. So the final line is, it was never the intent that these provisions would provide blanket protection for trees in urban allotments. But there's nothing in the NPSIB talking about the difference between trees as opposed to other types of indigenous vegetation, for example. And if indigenous vegetation, which necessarily includes trees, is captured in a blanket way, well, clearly it is a blanket approach that they intend will be taken to clearance rules, which is what they're talking about here. I don't recall seeing in the section 32 for the NPSIB specific discussion of how it interrelated with the NPSUD. It's mentioned, they mention how they go through the process of saying, well, the coastal policy statement will trump, other policy statements will sit alongside, neither trumps the other, you have to reconcile them, but other than in that general way, they don't go into what this will mean in an urban environment.
Well, I have a suggestion as to a possible reconciliation route, and that is to ask you whether it's arguable that protection of Indigenous biodiversity is an aspect of a well-functioning urban environment.
Oh, it is. I think it is. I think that living in a sterile concrete jungle is not a well-functioning urban environment. There's a lot of evidence about the benefits of protecting the existing tree canopy. There's the green, which report it was. There was certainly in probably the Green Network Plan, and the council has an overall strategy, which I think probably fed into the district plan of enhancing the green network throughout the city, and obviously the town belt plays a significant role in that. So I certainly agree with that. The other part of that is that well-functioning urban environment is a very broad concept. When you look at the NPSUD, actually it's very directive about building heights and densities in centres and walkable catchments of centres, and then the MDRS comes in not through the NPSUD but actually through the legislation that was passed. So in some sense, there is no conflict where you provide rules to protect Indigenous biodiversity in residentially zoned areas And as long as you're not affecting building heights and densities in the provisions that you create within, say, centres areas, it is something that can, or in principle, should be able to coexist.
Looking at the, sorry, Lindsay, I cut across you. Thinking that, looking at the viewer that you provided us with, it seems in practice, the urban SNAs on private land that were deleted weren't in centres.
No.
In fact, they weren't even in the inner city at all.
Mm.
There were some at the back end of the Yarrow Valley. Mainly they're in the western suburbs. I haven't looked. This will be something for Mr. McCutcheon to advise us. I didn't have in my mind the area that has now been zoned high density through the Johnsonville line corridor, as to whether there is an overlap between those potential SNAs up there and that. So that might be an issue.
I suspect there might be a little bit of overlap there, but by and large, my feeling from the viewer when I looked at it was it's all in the hills. There's nothing in the sort of the flat CBD through Mount Cook area and Newtown. It's the hills.
Yeah, that's right. And it'll be the Johnsonville line corridor where it'll impinge on high density if it impinges at all. What's the answer, Mr. McCutcheon? Are you able to tell us?
Certainly. So if anything, the biggest conflict or the areas with most unidentified SNA on residential sites would be along the Johnsonville rail corridor and in its vicinity through Nio, Crofton Downs, Kandala, around those suburbs. There was a significant amount of unidentified residential SNA which was removed in the notification of the plan.
So there is a conflict, and you can say, in your point, what I've written down, there's no conflict if you protect biodiversity, so long as you're not limiting centres HRZ, but in that area you would be.
Yeah.
And as regards the extent to which urban SNAs would affect MRZ land, that's a much broader economic issue as to whether that is impinging on the council's ability to meet its 30-year.
That's right.
Realisable, the amount of realisable capacity is sufficient to meet the 30-year predicted demand plus the required margin.
That's right.
And
then you start getting into making judgment calls where if because of if the experts are saying that the impact of your SNA management rules, it has reduced the realisable urban capacity beneath the required level, then you either need to rethink the rules or you need to rezone more land to make it, to get yourself back up above the bottom line.
That then, in Wellington context, and say, well, where are you going to go?
Mm.
Given that, unlike Auckland, there isn't potential to extend out over the horizon.
No.
Oh well, that's useful. And now, in terms of interpreting the bill, thank you for your helpful submissions on this issue, which is next me trying to figure out what that means. The issue, I think, that we have to grapple with, or we have to understand, we don't have to grapple with it right this minute, but the reality is there will be a bill that becomes an act before we finalise our decisions. And this produces a procedural issue for us. So I want to float my current view on how we would address that. We also have the Greater Wellington RPS decisions looming. Now, Mr. McCutcheon has done his best to anticipate where that might land by referring to the reporting officer's final reply version. But of course, there are 2 steps beyond that, both of which might produce material changes in the panel's decision, panel's recommendations that we don't know yet know, and then the council's decisions on those recommendations, which we also don't know and won't know until, I think, the 26th of September.
Yeah.
Or shortly thereafter. My intention at the end of this hearing is to make directions that when those decisions are released, to request Mr. McCutcheon to write us a report. Basically, have the goalposts materially shifted? Yes or no? And if yes, in what respects? And do those changes cause him to alter his recommendations? And then to invite other parties to provide their view on that paper, that question on paper, and for Mr. McCutcheon to reply. Now, I think we can put that to one side. Like, there's no point guessing where the regional council will roll. I think the bill is a different kettle of fish. First of all, because we don't know what timescale it's going to return to the House. Do you have any information?
No, so based on the website, there's no indication at all. Based on the text of the bill, it's anticipated, or at least it was when it was introduced, that it would be this year, because they specifically refer to it in subclause 7 of proposed section 78, that the minister may amend the NPSIB to make changes as a result of the enactment of the Resource Management, Freshwater and Other Matters Amendment Acts 2024. So we know that they at least anticipated it would be this year. I mean, I think we can also say that when it comes back to the House, it will be dealt with under urgency, because that's the way they're doing everything else. So we will I don't think there will be a long lead time from when the select committee reports back to when it becomes legislation. But of course, the danger in trying to proceed as if this section stays the same is the same as trying to guess what the regional council will do. It's entirely possible that there will be changes to this section, and so adopting a course on that assumption is a risky one.
Yes, and so the same, my plan is effectively the same. I think that we get a feel for what we think this bill means if it enacted in the current form. I think that between the two of them, the bill's far more likely to move substantively than GWRC's decisions. It's the nature of the beast. So it is much more likely we'll need to have a go round of some kind when the bill is in hand to say, well, what difference does this make? But
and in one sense, I mean, I tried to if it stays the same, I tried to answer that in my submissions, because subclause 6 seems very clear that it does not affect any SNAs that are included in a proposed plan before commencement. Commencement being when it becomes law sometime in the future. So the SNAs that are already in the Wellington City proposed plan are not affected by this section.
Minor extensions thereof.
And so the question is, if an extension of an SNA that is already in the plan, in the proposed plan, does that constitute a new SNA, or does it extend an existing SNA, or otherwise unchanged, not engage it? And my view is that it does change what's being proposed, that the new area, the new extended area, or the area of a newly proposed SNA would be caught by the bill. It's not that assumes that your recommendations and the council's decision come after commencement of the bill.
I think that's a safe assumption. That with the best will in the world, the idea that we will have completed our recommendation report, like on this topic, if we do it by Christmas, I think we'll be doing well.
Yes.
Particularly if the goalposts shift in the meantime.
That's right.
And then you get into the vexed question of what
5 means.
What 5 means.
But again, that's in one sense, that's not really a question for you. That's going to be a question for those determining resource consent applications that are made, because the question for them will be, if the plan becomes operative at some point in the next 3 years, then did those SNAs did they become part of a plan after commencement of the bill? And they will have, in theory, because it will have become part of a plan after commencement. But that's where I get into the question about how you have to read 5 with 6, so that I think they're not affected in that way.
So the thing about 5 that's puzzled me is it's framed in the negative. It says what they're not. It doesn't say what they are.
Yeah. For example, can you take them into account when you're considering the objectives and policies of the plan, for example, under 104,
Exactly.
as opposed to, I mean, I think it's clear that it's intended that they don't, any rule framework wouldn't apply, but you have to then read this section with 104 Does it somehow, do you take it into account in an objective and policy sort of basis, or do you, even if a particular rule is not to be treated as operative or not to be treated as an SNA?
Like, if it said they're deemed not to be areas
Mm.
of significant Indigenous biodiversity,
Yes,
then it'd be a lot clearer.
it would.
But it doesn't say that. The other issue that I wanted to raise with you is reading these key clauses of the bill. Had you considered the notes to the bill? Because there's a reference at the bottom of page 3. I'll read it out to you. Changes in the bill do not affect or prevent identification or notification of new SNAs and policy statements, proposed policy statements, proposed plans or plan changes during the 3-year suspension if required by a court order or other outcome as a result of existing proceedings or processes which are preserved by sections 32 to 33 of the Legislation Act. Does that mean, like, clearly this is an existing process, if a new SNA popped out of this process, or an enlarged SNA popped out of this process, is that in a different category to new SNAs that are notified post commencement for the purposes of what the bill drafters were trying to achieve with subsection 5?
Well, we know, so I did read the explanatory note and I recall that passage. What I thought when I read it was that there must be some proceeding, either a declaration proceeding before the Environment Court that I'm unaware of, or a judicial review, for example, about whether, and I had heard that Forest and Bird, I think, and I mean, I don't know whether this is right, but I heard a rumour that Forest and Bird had judicially reviewed or sought declaration proceedings in the Environment Court to the effect that a particular local authority, I think down south, had not given effect to Section 6 of the RMA because it had not protected significant Indigenous vegetation and fauna through a recent plan change.
Clearly they did that in New Plymouth.
Well, yeah, so I'm unaware of the details.
Because we
I'm
know
aware it
because
must
we
be
know
somewhere.
that we've got the decision in that. So the precedent's was set.
Yes, and I think there is another one somewhere else. And what I thought that passage was doing was trying to protect
Probably
the outcome of that proceeding, as obviously the Crown is obliged to do through its responsibility to respect the comity between the branches of government. So to the extent that a court might order.
Currently opposite.
Yes, exactly.
Topical issue.
We're all well aware of it now. But so that's what I thought that was protecting. It didn't occur to me that it might also be protecting something in this process because, as I said just earlier and in my submissions, I take the idea of an extension to an SNA that is in the plan as being something that, if it comes after the bill has been passed, it will be affected by subclause 5. It will not be treated as an SNA to the degree of the extension. But what you're saying, but pulling those threads together in a way I hadn't previously, it may well be that actually an extension to an SNA that exists in our proposed plan today is one that is not affected because of the process that is referred to. It's not really what 5 says, though. It may be what the explanatory note intends, but I don't know that concept has been sufficiently brought into 5, if that's what it is.
The question might better be, does the Legislation Act have that effect?
Potentially, section 32 and 33, I think you said, which are the ones that say if you have a right or a power that exists before legislation comes into force, then you may have
Yes,
you can continue
and if you're in a judicial process, then you're entitled to finish the
That's right.
process.
Yes. It's interesting. I don't know that I would have thought the Legislation Act that concept applied to this process as opposed to, say, an Environment Court appeal, but I would have to dig into that.
Well, I think I need to ask you to do that and give us a considered view.
Yes.
In the council's reply, not anytime soon.
Yes, no, look,
Like
that would be helpful.
The issue's not going away.
No. And there might be case law about, does it need to be a judicial process before a court or tribunal? Or,
Well, that would be the acid test.
Yeah.
And which clearly we're not. Now, in terms of your discussion of natural justice, the 4.4 I wondered if there are two natural justice issues here. The first is about SNAs, and Mr. McCutcheon has set out his stall on that basis. I understand his logic. The second is about Indigenous biodiversity outside SNAs, and I think Ms. Whitney has said, well, what's the difference? How would the general public have understood? Would the general public have expected a rule framework constraining clearance of bush, which is not identified as an SNA, to emerge from this process? And without wishing to put words in Mr. McCutcheon's mouth, my reading of the message between the lines in his rebuttal supplementary evidence was that he was wobbling on that question.
I don't know if he was wobbling on it. I think he sees them as different, and he's set out 4 or 5 reasons why they are different. And really the question for you is, do you agree with that assessment? Or is it one where the same approach is justified for both because they're materially similar? And I think that that's well within your discretion to make. And given there is, as Mr. McCutcheon said this morning, the necessity for there to be a further plan change, that's another factor that might come into your reasoning. It is going to have to be addressed by the council in reasonable short order, again subject to the potential 3-year postponement for some of the obligations. But this wouldn't be one of them, for example. So the council would have to go back to the drawing board and progress a plan change as soon as reasonably practicable.
The thought that occurred to me was that sort of standing back and saying, what would the citizens of Wellington reasonably expected as regards the SNA versions? They might reasonably have expected the SNAs to come back in as at least a possibility out of this process. But it's hard to think that anyone would have expected the directive framework that is now in the NPSIB to apply to those. Basically, it's the difference between, is the effects framework available or isn't it? And in a way, where Mr. McCutcheon has landed with the Indigenous biodiversity outside SNAs is as if SNAs had come in, but under the old rules, under the RPS rules, so that the effects framework was required. So that analysis would support the differentiating between the two. That there. So, what's your view? Is the merit in that line of thinking?
Ms. Whitney's line or Mr. McCutcheon's line?
No. In the idea that the SNA, it's not the fact that SNA is coming in, which is the natural justice problem. It's the directive protection avoidance with limited exclusions in the NPSIB that no one could have expected.
Well, look, there is merit in that view. My instinctive reaction was actually the other way, that the citizens of Wellington would not have expected that SNAs in residential areas was a potential outcome of this process, because it had been ruled out in a reasonably high profile way by the councillors when they made decisions to notify the plan. And I think, as I put in my legal submissions, I think a lot of Wellingtonians turned off the process at that point. There had been quite a lot of engagement by residents associations and residents themselves concerned about the potential for their property to be affected by an SNA, and it's merely a personal reflection, but it seemed to me that a lot of people turned off when the council took that step back. So, and then you have the NPSIB, and we have the legislation before Parliament, and so it's clear that there is a more rigorous management regime on the horizon. Whether Wellingtonians would have appreciated that it was a likely outcome or potential outcome of this process, again, my personal reaction is that I would have thought they might, given that it was sought by submitters, Regional Council and Forest and Bird in particular, and there is discussion about that sort of in the general public discourse. But I can certainly see the view that until it is a mandated obligation, which we now have at the NPSIB, but that came after notification of the plan, Wellingtonians may not have submitted on the basis that it was a potential outcome.
And while submitters were seeking it, they were seeking it on the basis of a draft which had no legal weight.
That's right. Yes, and to be, I mean, I feel very uncomfortable about the idea that a party can, by making a submission that says something along the lines of make the rule framework consistent with this draft document, effectively bring forward the implementation of that draft document to the extent that it changes. It provides a very broad scope, and I don't know of any law that sort of suggests that that's too much for the public to have to understand when you're thinking about the scope of submissions, but I do feel very uncomfortable about that.
Well, I suppose that you don't have to read very far into Mr. McCutcheon's 42A report to realise how complicated it is, which immediately, in my mind, raises questions about how much of this could any
reasonably and fairly, in
any citizen who's not a planning tragic,
Mm.
who's all over this like a rash, just a landowner with some bush on their
Mm.
on their urban property, be reasonably have expected to be conscious of.
That's right. Now, the RMA is not particularly prescriptive about the way in which you make a submission and the relief that you seek. So it doesn't, for example, say that relief must be, specifically stated in terms of objectives, policies, and rules. So you can have relief very broadly stated, but when you think about the scope of submissions and the way the courts have approached it, is something on a plan change, is it something that other submitters could reasonably and fairly have taken from the submission? I do think it raises a question as to whether other submitters could have taken that reasonably and fairly from the submissions that are being relied on to provide such significant scope for these changes.
So I've dominated the discussion. Mr. Dave, do you have any questions, Mr. Whittington?
I don't think I do at this point. I think, it's been a reasonable outline of some of the challenges that we're facing with having to deal with what this hearing and then what the final product of the plan will be. And I think, I don't have any particular questions or even comments, but it is going to be challenging.
Mm.
Mr. Murray?
And likewise from me, Mr. Whittington, thank you for your legal submissions and for the discussion this morning. It's been really helpful.
Thank you.
Well done.
Well, should we talk about economics?
Exciting bit. Good morning. As you've seen, my name's David Norman, Chief Economist at GHD and formerly Chief Economist Auckland Council for 4.5 years. So I'm quite familiar with these kinds of challenges as they relate to central government policy and local government implementation. I acknowledge I appear here in compliance with the Code of Conduct for Expert Witnesses set out in the Environment Court's practice note, noting, of course, that this is a council hearing rather than an Environment Court proceeding per se. My involvement with Wellington City Council in terms of trying to quantify some of the costs and benefits of the various elements of the proposed plan change range from much earlier work on water sensitive design through to what I think is more relevant for today, my work on the costs and benefits of the SNA proposals, both including and excluding SNAs on residential land. And then most recently, as per my supplementary evidence, the costs and benefits of the proposed further Indigenous biodiversity protections across residential areas. So I'm happy to summarize my work or take any questions, whatever works for you.
Well, I think we should just how into it and see how far we get. But first of all, just to be clear about structure, as I read your evidence in chief, it's a summary. The guts of your analysis is all in the report.
That's right, in the original report, and then because the
and then the supplementary to discuss the out of SNA.
That's right. That work hadn't been done prior.
I had a number of questions about your report. You're starting at the foundation data on page 3.
Just bringing it up. Yes.
Bar graph. I was interested at the first 2 columns.
Mm.
That 0.14 of a hectare seemed awfully large
It's large, yeah.
as an average SNA coverage per private residential lot.
That's right. So these are predominantly larger lots, as you would imagine, for the identification of the SNAs. This doesn't go down to much smaller properties. So I was reliant on data provided by the council. But yes, relatively large. Some of these sections may have been up to, a hectare or more in size, even though they were residentially zoned.
I wonder if I could turn to Mr. McCutcheon. Where would those be, Mr. McCutcheon? Like, I was trying to think in terms of the zone framework. Like, obviously you have the three development areas, which are now residentially zoned, but they weren't so they won't have been included because they weren't residentially zoned when this report was done. So where is the large sites, large residential zones sites?
Certainly. So Mr. Doherty will speak to the Kilmarston blocks in his speaking slot, but that's one that immediately comes to mind. So that's around Nio, Crofton Downs.
Yeah, I know that one. Yeah.
So there are some significant sites there, as well as up around the Nio Gorge. There's some pretty large residential sites.
Oh, that's what Mr. West
Yes.
is talking about. So those sites that are in that, is it Northern Lights subdivision?
Correct. So yeah, top of Old Porirua Road, there's some very large sites around there, as well as in the Kaiwharawhara, sort of around Onslow Road area, there are some significant size sites. In Newlands as well, over the coast side of, say, Blackrock Road, there's some large residentially zoned sites up there, as well as in Karori, Brooklyn, down the Long Gully, down towards Long Gully.
So
there are some significant.
So at the margins there are.
Yeah.
I actually have addresses here. I don't think it's appropriate to list those, but I do have, it ranges from Granada, C2 Newlands, as you've talked about, Tawa.
Yeah.
For just in the interest of transparency, there is a function which can be enabled on this dashboard to show proportionately the how many sites are, say, covered in 0 to 10%, 0 to 50, 0 to 75, and also the query function. So clicking on one of those orange sites can return the percentage of coverage for that particular site down to the the square meter number. So that is a function which can be enabled should the panel find it of assistance to themselves.
But wouldn't it be fair to say that a lot of those sites that you were talking about haven't been developed because they're either difficult to get at or they're very steep as well? Wellington has residential growth, and Wellington has been all about building on the easier land first and leaving the more difficult and more costly land, which often is covered by bush of some kind, till another time.
There's also the fact Mr. West points out that Northern Lights subdivision's got protective covenants over everything that's not built on.
Mm. Did you need to? Oh,
so
in terms of response, yeah, I mean, so that may well be true. I have the primary zoning for those properties here in front of me as well. Everything, some of it's medium density residential, large lot. Large lot I anticipate would be possibly have some of those protections you've talked about already. but the majority of it seems to be in medium density residential.
The Norman, going to your analysis of rural land reduction
Mm.
and using a base, using Manawatu Whanganui as to provide your base information. Is there a problem with that comparison, given that the rural land in Manawatu Whanganui is much more productive than the rural land in Wellington City? I don't know, like obviously there are actual farms in Wellington City like Terrafiti Station and the one next to it. But it's pretty scruffy land. Don't know what sort of output you're getting off it. It's not, you're not running dairy cows up there.
No. So so for the comparison, I limited my analysis to sort of sheep and beef in the Manawatu to try and make it comparable rather than, the most highly productive land. And I think crucially for my analysis is that, well, a couple of things. Firstly, I obviously scaled it for relativities in land value differences between the Manawatu and Wellington. The reason I had to use the Manawatu was to get a credible number of properties on which I could do my analysis. There just aren't enough of them in Wellington City selling at any time for you to be able to get a reasonable picture of land values. So I scaled the land values. I applied, as I say, sheep and beef for the land use. And then the third element is just to remember that my analysis assumed that land that could be used productively was being used productively for farming purposes, and given that your primary goal there is production from the land, and therefore land that is currently or that remains covered in Indigenous biodiversity is likely to be the less productive land on that site, or you would have replaced it with grass or whatever else was needed to be productive. And so I assumed the lowest land value in terms of the sloped land value that I think is appropriate to capture land that wouldn't be massively valuable from a production perspective.
I suppose the question is are Wellington rural land values related to production at all?
Well, I would suspect they would be. This is not lifestyle sized properties. This is rurally zoned property. Notwithstanding that some people may choose to make them into a lifestyle choice. Also, I'd add the following, which is that land values are a function of their potential use, not their current actual use. So I may be using that property as a lifestyle property of 20 hectares or something larger, but its value is the value of its potential use by the next owner, what the next person's willing to pay me to use that land. It's not a function of my own use. And I think that's very important, especially if we move on later to discuss, residential SNAs or IB protections more broadly. Mr. and Mrs. Smith living on that property for 42 years and approaching, departure to the retirement village may have no intent of developing that property into housing or additional units. That's irrelevant. The value of their land is the value of what it can be used for rather than its current use.
At 5.3.1, Norman, you talk about the used UK willingness to pay values, converting that to New Zealand dollars.
No, it's a little different to that. Sorry, did you want to finish before?
No, so that was how I read your 5311,
Yes.
and I was going to ask you convert how.
Yeah. So we don't use the UK values per se in the analysis. What we did was start with a New Zealand study and international studies to get some idea of what was available out there. There wasn't a huge amount available. We relied on the New Zealand study as being the most appropriate for New Zealand. However, one important deficit, I suppose, in the New Zealand study, and something that the UK study assisted with, was the important question of use versus non-use value. So the clearest way to describe this is if we're looking at biodiversity protections on private lands, so whether it's residential or rural, doesn't really matter. The protection of that biodiversity comes with no additional access to the public. So there is a benefit to the community of knowing that biodiversity is being protected somewhere, but unlike publicly owned land or reserves and other places, the public doesn't actually have access to that amenity. They know it's preserved and that is value in and of itself, but that's going to have a much lower value than if it was actually somewhere you could access yourself. The New Zealand study did not tackle the question of use versus non-use value. The UK study did. And so we used the relativity between use and non-use values from the UK study so that we could separate out the average value in New Zealand into use and non-use, but we didn't actually apply the UK dollar values or pound values, if you like. I think, I don't know if this will come up later, but one of the points that the Johnsonville Community Association raised was exactly on that point. One of their critiques of my work was that they pointed out that the privately held land would be inaccessible to the public, but they seem to have missed that I had actually dealt with that in my report. So I've limited the privately held land to benefit values that come from non-use value only.
In relation to the willingness to pay, you're saying 533.
Yes.
You're saying typical preference, stated preference studies overstate willingness to pay when compared to revealed preferences.
That's right.
The thought that went through my mind is that, is there an issue in this case with people understating their willingness to pay for things that they're not used to paying for, don't expect to pay for?
The literature suggests the exact opposite. So usually when people are confronted with open-ended questions and are not required to materially and concretely consider the trade-offs, they tend to overstate how much they value things. So, I always jokingly use the example of when you ask someone if they care about something like heritage, they all say, yes, absolutely. And then you say, brilliant, your rates are going up $500 a year to pay for it. And that's when they say, I don't really care about heritage that much, because suddenly they're being confronted with the trade-off that they're being required to make. So the meta-analysis that I used for those sort of modification factors there suggests that overwhelmingly people tend to overestimate their willingness to pay in stated preference studies because they are not being confronted with those trade-offs that they need to make. Nevertheless, I do provide two adjustments. One which all but keeps it at the stated value, so it divides it by only 1.1, so effectively you maintain it at 90% of that value. and then a much lower figure, which some of the studies in the meta-analysis I used to demonstrate this suggest.
The other thing is that it's easy to overstate a readiness to pay when somebody's not asking you for the check.
That's my point. Exactly right. That's my point. Yeah. So, so better studies, in my view, and we've done some of these in New Zealand. I've been involved in some. You present people with a range of scenarios, and they have to pick between them, and that forces them to confront the trade-off that they might be able to make. It allows you to get a more reliable picture. But in the absence of that, I've had to include some sort of manual way of allowing for the possibility that people are overstating this benefit.
And that's all I had on Norman's report. Did anyone, Lindsay, did you have anything on his report?
No, just to carry on from that. You've gone through this analysis and you've put in various assumptions and so forth, and you've justified why those assumptions are. I guess in terms of the way I read it, the cost side of it to come to a BC is easier, and the benefits side of it is much more difficult. And I think you were explaining the part of the reasons why in terms of people's preferences, and they might not be able to confidently confirm whether or not they'd be prepared to pay $500 additional for heritage if that was the situation. I guess when it comes down to actually having numbers at the end, you've got relatively broad band for the rural and the public open space or the public land. But you have, I think in terms of, I did see the figure before, but you have a smaller band for the private residential properties.
You probably haven't seen it because I didn't include it, but I am happy to answer that question.
Yeah, and I just it's all a matter about putting the assumptions in and pushing a button and getting a number out. But I just wondered why there was a narrower band.
Yes, so I'm not sure I understand exactly what you mean by narrow band. You mean
within the BCR calculations?
So it's a ratio of about 2.5, which reflects that upper and lower bound value for willingness to pay. But you raise an excellent point, which is that that what I was tasked with was looking at everything in SNAs and then looking at the rural and open space. I didn't actually explicitly comment on residential. You could have, done the maths yourself by subtracting, but that's a little bit complicated. So I have since done that at Mr. McCutcheon's request in the last week or so. So as your logic would tell you, if you've got an overall BCR there in my base case in the original report of 0.3 to 0.29 to 0.71, but the BCR for only having SNAs on rural and open space land is higher, mathematically that must mean that the residential BCR is lower. I've since calculated those just in case I got asked, and so it's a good thing I did. So the BCR on residential only is between 0.06 and 0.16, so massively lower. In other words, in the most generous scenario in terms of benefit, the costs in terms of reduced land values and reduced ability to produce housing would outweigh the benefits by a factor of 6.
Okay. So just to sum up my understanding, people really like to have other people's Indigenous biodiversity, but don't want any of their own. Is that from an economic perspective, is that a fair thing to say?
People value biodiversity, but there are very real costs associated with requiring it in terms of your ability to deliver housing that initial work was around 1,300 homes, probably would not be built as a consequence, or potentially couldn't be, might not be, and a material impact on land values in the, I do have the actual figure here. It was a lot, about $50 million in terms of reduced land values.
Okay, thank you.
Kia ora, Dr. Norman. Nothing further from me, but I just want to take the opportunity to thank you very much for your report and the evidence and supplementary that you provided. Yeah, very, very helpful and interesting, if not somewhat challenging.
Thank you.
Thank you.
Is anything on Mr. Norman's report before we'll come back after a cup of tea and talk about his supplementary evidence?
Thank you.
Well, we'll have a break and as I say it, be back at 11:15 and we'll have a few questions about your supplementary evidence, Mr. Norman. So, Mr. Norman, we're resuming the hearing, starting to discuss with Mr. Norman his supplementary evidence. I want to ask you really only one aspect of your supplementary evidence that I want to ask you about, and that's the statement at 28.2, the way you factored in so the sequence, 50% of parcels with over 100 squares of vegetation cover are covered in indigenous vegetation. 10% of parcels that would otherwise be developed are discouraged from being developed. The question is the word would.
Mm.
Is that would or could? Because I have in mind the evidence we heard last year from Mr. Phil Osborne about the difference between what the zone provisions theoretically
Yes.
provide
Yes.
and what capacity is realisable.
Yes.
So is that 10% of the realisable capacity are discouraged from being developed?
So I'll address your question. It's a great question. I'll address it in two parts. One is simply to point out that the percentage I've used here is an assumption, right? So I have a whole bunch of sensitivity analyses at the end. So we don't want to be hung up on the percentage, whether that's 5, 10 or 75. It makes little material difference to the main point, but I appreciate that's not your question. The reason I've used would is because, again, I'm taking a long-term view here. So this could be a 30-year view or a 50-year view. So if the land is zoned for that use, and if in the data that I've been provided by the council, that is sort of, there was a feasible development from a physically feasible development perspective, ruler run over it. And then the assumption is over time, land becomes developable even if it isn't now. As land values rise over time, that tends to make land developable. So the key message is this doesn't have to be land that has a developer lining up to buy it today to develop. It's over the next 30 years. The land value reduction happens regardless because of its potential use in future.
I suppose the logic of Mr. Osborne's modelling was that he was predicting, as he's required to, as the council's required to assess the purposes of the MPSUD,
yeah.
realisable capacity over
Yes.
30 years.
Yes.
And the numbers, because we had an update of the numbers, and the numbers of realisable capacity had reduced, notwithstanding the fact that the theoretical enabled capacity had increased through the council's IPI decisions. And the one I recall was that excluding greenfield capacity, there were about realisable capacity was about 39,000 units.
Across what? Sorry,
across the Wellington urban area.
in total, right?
Realisable units. Right. And I looked at your figures in figure 4, and I'm thinking, just take the top line of
Yes.
sort of 17,000 or 20,000 current dwellings, 17,000. That's a colossal proportion of the 30-year realisable development, and which suggested to me that clearly wasn't what you were looking at. So were you looking at the theoretical planned enabled capacity or something in between theoretical, because I think the feasible capacity is not physically feasible. There are economic elements in that too.
Yes, so this is
This
as
is,
I understand it, and Mr. McCutcheon, I don't know if you know anything from Josh's work, but the 25, so if you look at that first row in figure 4, you've got 17,500 properties affected, or as an upper bound. The estimated, my understanding was physically feasible capacity on that land is an additional 25,000 dwellings, 25,357 you've got there. So around 1.5 additional dwellings on average across those affected properties. So physically feasible capacity.
yeah. Which is somewhere between, in the MPSUD step down from theoretical to feasible to realisable, is somewhere between theoretical and feasible.
Yes.
Somewhere.
Yes. Yep. Yep. It's worth us checking with.
And follow up on the precise terminology, whether it be feasible or realisable in return.
Yeah, because as I say, my understanding or recollection, understanding is probably putting it a bit high, recollection of what Mr. Osborne told us last year was that feasibility was not just physical feasibility. There was an economic lens. It clearly took into account physical elements, but there was an economic lens as well.
Correct. So in the work that property economics did, it assumed that either an owner, developer, or a large-scale developer would assume different levels of risk, and they would be comfortable with different levels of risk and accordingly return, which would impact on what was theoretical to what was feasible to go ahead, but then may not, in that realisable step, may not actually be built.
Yeah. Okay. So I suppose the punchline is that if you base that on physical feasibility rather than what we've been told is realisable, what's the implications of that, if any, for your analysis?
I'll just pause. Can I deal with that? So, yeah, input from Mr. McCutcheon's colleague who helped evaluate this suggests that it is the realisable capacity. We happy with that?
Yes.
Yeah. So it is realisable capacity. I remember it did come up in discussion a few days ago as to the wording and whether we should be saying realisable. Now we know why. Yeah. Yeah. Yes. Yeah.
Well, yeah. So the punchline then is, so if you're talking or extra potential capacity reading off figure 4, 25,000, that's like 70% of the total realisable capacity. And so am I reading figure 4 correctly, that if it's not actually, well, maybe I should pose this question. Extra potential capacity compared to what?
So it's over the existing dwellings today. So if you look in, it was just for the purposes of clarification, which maybe has achieved the opposite. So my apologies, but so you've got affected properties affected. You've got current dwellings, which is how many dwellings are on those affected properties today. And then there was how much capacity is there to add additional units to what is there today. So in other words, your 20,000 dwellings could become 45,000 dwellings if you added the extra 25, either with replacement 1 with 2 or just adding to what was there already.
in that case, maybe you've got a better, you probably do have a better memory than I have, Mr. McCutcheon. Can you recall what is the number of existing dwellings in Wellington right now?
I can give it a crack if you can't. Well, we've got around 87,000 households, so it will be roughly that figure. Sometimes there's more than one household in a dwelling, but it'll be around the 80 to 90,000 mark.
So when that was the base, and so for instance, Mr. Osborne's 39,000 realisable capacity units, they're additional units, so that 25,000 is a proportion of that. So is another way of putting that, if you didn't have provision for 100,000, you just had a complete preclusion, you would have 25,000 less homes. Similarly, if you didn't have a 200 square metre, you'd have 19,000 less.
There's one additional thing that we haven't considered there, which is the uncertainty over what share of these properties are actually affected by Indigenous biodiversity. So the Council of Arboriculturalists' view is it's somewhere between 40 and 70%. So you could roughly halve those numbers. The estimate is more like half, about 12,500 in the case of the 100 square meters. So the purpose of this table was just to give you the overall impact of not considering, not evaluating properties if they were removing vegetation less than that 100, 200 or 300 square meter trigger. But in each case, you'd then have to evaluate the Indigenous component, which is estimated at 40 to 70%, so roughly half. So the potential development at risk would be around half of each of those three numbers, so about 12,500, 10,000 and 8,000, depending on the trigger point.
So assuming the last, allowing 300 square metres, if 8,000 would take you under the predicted demand plus margin, which would clearly be an NPSUD problem. Putting it objectively, perhaps understatedly.
Can I just ask a follow-up question on
go
that?
for it. I'm writing this down so before I forget it.
I'm taking it that you've taken some of the projected dwelling capacities as a given based on other people's work, rather than particularly in terms of what's feasible and what's realisable, and so forth. Because I recall last year we had quite a discussion around the numbers and how they were derived, and certain things were easier to determine, such as the physical land cost, development margins and those sorts of things. But one thing I do recall that there was a large amount of uncertainty in terms of the projections was if you like, agglomeration effects. If you've got a 600 square metre property compared to something which is 2,000 square metres, you can probably get a lot more on 2,000 square metres than you can on 600 per square metre basis.
Yes.
So you've just essentially carried through those projections in terms of the impact of having Indigenous biodiversity restrictions in terms of getting these numbers here.
Yes.
Which,
So
as I think you said, are quite significant numbers.
the potential capacity was provided to me via property economics, was it? Yeah. Yeah. So I did not calculate those figures myself. No.
Okay. Thank you.
Something else you could helpfully explain to me, Mr. Norman.
Sure.
I'm sorry, I'm fixated at your figure 4.
That's okay.
I can't understand the logic of why it's a area of Indigenous cover before right quarrying. If it's 100 square meters, it's a large number, and if
Yes.
it's 300, it's a small
Yes.
number. Why isn't it the reverse?
It's the number of affected properties, right? So if you if the trigger point is 100 square meters, we capture a far larger number of properties. It's whereas if it's a 300 square meter trigger point, there's a much smaller number of properties that have, the technical term here, a blob of vegetation that's at least 300 square meters in size.
But you're saying the extra potential capacity of having 100 square meter limit is 25,000. If there are far fewer 300 square meter blobs of Indigenous biodiversity, then I suppose the extra
The extra is reduced. Yeah, it's fewer properties affected effectively. So we're counting in the first row, we're counting the number of additional properties or dwellings. Let's just use it for simple terms. The number of additional dwellings you could construct if there wasn't such a limitation. And then if you make that trigger point more relaxed, there's fewer properties that are caught up in those restrictions and therefore a lower number of
fewer properties with more dwellings. But the way it works, you say you've got implied extra dwellings per property.
Yeah, so that's a really interesting point. So because the more relaxed trigger point, so say using 300 square meters, affects a dramatically fewer number of properties. It means far fewer are caught up in the requirements at 5,800. But because those tend to be bigger parcels, which is why they can have blobs of over 300 square meters, it means that the potential capacity on those properties is greater than on the sample overall. And so the actual number of dwellings per property is higher. So that implied extra dwellings per property is simply taking extra potential capacity column and dividing it by affected properties. So the average size of those sections captured that continue to be captured even with the more relaxed trigger point is larger, and therefore the development potential is greater on those sections.
I think that well, as is obvious, I'm struggling to understand how this works. I think what I need from you, Mr. Norman, is a table that starts with, does the reverse calculation, starts with the realisable capacity and tells us what are the negative impacts of different Indigenous biodiversity controls
Yes, I
on that
understand.
realisable capacity.
That makes sense. I'm happy to provide that. Is that something I can do as an additional? Yeah, I mean, again, I will probably use my base case assumption that half of it is Indigenous biodiversity, but then just walk you through the implications of that.
Like probably, when I said a table, I do mean a table with some with explanatory notes.
Exactly.
So that we don't have to come back to you and ask more questions.
Very happy to do that. It's no problem at all.
I think from my point of view, that's a matter for council reply. Like, this is not action this minute. From your point of view, Mr. Norman, that means probably 4 weeks. Like,
I should be able to do it
Mr.
in about 20 minutes. But yeah.
Mr. McCutcheon might have a timeline of his own, because so your thoughts can feed into what he tells us.
Yep.
But it's some distance away.
Very happy to provide that, sir.
And the last and winner and the realisable capacity numbers I've been muttering about were those that Ms. Hampson analysed in the Stream 10 hearing, because with the council's consent, she got a rerun of the capacity model for the purposes of the discussion of the OLS designation.
Pretty much on the 39,006.
Yeah, could I just make a comment, and you can observe as necessary. You've got these 100, 200 and 300 square metres of Indigenous biodiversity, and it's just taken off some assumptions which have been made by others, but there's been no sort of ground truthing of whether if there was 300 square metres of Indigenous biodiversity, whether it was developable on that land or not. Just thinking about Wellington's topography, thinking about access issues, thinking about the extent of earthworks which would be required to develop a lot of this land which is covered in bush. It seems those numbers appear on the face of it to be high because of what are possible development constraints on that land in the first place. So have you got any comment? You're just using the best available data and some assessments which have been done about what is feasible or realisable development capacity.
That's right. So I haven't done the work on realisable capacity myself. I am relying on the data that I've been given, which obviously it doesn't take account of, say, slope or Indigenous cover. Well, sorry, that's not true. My work does not separately take account of any additional information on slope or Indigenous vegetation cover. So I don't have that information on a site-by-site basis.
So would these figures be like a worst case scenario in your view? Like
no,
in terms of potential loss of development capacity on these properties.
Well, it's why I've provided a range. So I would I wanted to present a base scenario that I thought was credible. But the sensitivities, as I think I stressed a few times in here, are vitally important in that there are so many unknowns. Even if you were developing, how easy would it be to get a resource consent? Would most properties be required to revegetate or not? So what would the compliance costs associated? What would be the vegetation costs? In terms of the number of dwellings, if I vary my assumptions from most optimistic to least optimistic, you do get a very wide range. In clause 27 there, I point out that it ranges from 700 to 15,000, depending on how conservative or how generous, I suppose, you are in terms of how much development could proceed. So that is a very wide range, unhelpfully wide, perhaps. Although even if we were talking about 700 out of 40,000, it's not an immaterial number. That would be what, about 2%. My base case scenario was around 4,000 dwellings under the 100 square meter trigger point, which would be about 10%, obviously, of the realizable capacity. But I had to provide a range for that. The other parts of my analysis in terms of the actual costs versus benefits, the assumptions, as I demonstrate, were less material because the benefit stream and the cost stream tend to move in line. So if you were allowing more development, you would be imposing costs and benefits that moved in tandem, or if you did the opposite, they tended to move in tandem as well. So the broad message remained consistent, but with the number of dwellings, there is wide variation in terms of the actual number that you might affect ultimately.
Okay.
I think that's it for us. Thank you, Mr. Norman, for a very interesting discussion.
Thank you.
Look forward to seeing the results of our request in the fullness of time.
Very happy to. Thank you so much.
Thank you. Mr. McCutcheon, we're you gave us your general intro. Is there anything else you want to talk to us about these issues before we ask you some questions? Might be quite a few questions, actually.
Nothing in particular. Yeah, I thought it was a really good discussion and examination of Mr. Norman's evidence, and certainly as instructed, we'll return with some more detailed step-by-step description of what the impacts would be. Slope, I am informed, did form part of the PE work, which was used sort of as a proxy, which Mr. Norman applied more broadly to his analysis for this outside SNA control, but it would not apply on a site-by-site basis. So there would be, many sites where it would not be an accurate representation, quite possibly.
Yes, that my recollection of that process was slope clearly factored into the shift from theoretical to feasible.
Yeah.
But so did a lot of other things. And it was a modelled it was a model figure. It wasn't an analysis of individual properties. So there will be properties that vary from the norm in some up, down and round.
Mm.
Oh, well,
But just on that, my recollection was that slope was definitely taken into account, but there wasn't any factoring of how big the land parcel was. I made the point before, if you've got a bigger bit of land, you can get more on it than you can on a smaller bit of land because of the various site constraints there are on a site. I could be wrong, but my recollection there was that I think it was found too difficult to do that.
I wondered, Lindsay, whether the issue that PE didn't do was consider the effects of agglomeration rather than existing site size.
I'll look to.
I could be wrong on that, but you know, it was 18 months ago we had that evidence. So
I'll look into that matter in more detail.
Like I think the moral of the story is we'll probably go away and might be tonight's job, reread Mr. Osborne's description of the modelling process because it's a bit hazy. Okay, I think the way we'll do this is we'll take your report, Mr. Cutchin, in sections, we'll ask questions across the panel on each section before we go on to the next one. Some of which we addressed. Looking at the background start, your discussion of the backyard Taonga project and your paragraph 45 is sort of like the underpinning of the NPS-IB. And the question is, talking about question is, to what extent is that applicable to Wellington City, which is quite a unique environment and some very successful private or private and public initiatives, the effect of Zealandia, as you put it. You know, I lived in Karori and we carcass all over the show, and eating the lining of the roof, pulling it apart. But in a broad sense, like what you said in your opening, is like my reading of Wildlands, the supporting Wildlands report was that you had a deteriorating trend until the noughts, and then it's been upward ever since. An upward trend in biodiversity. Can we rely on that? Is you said that there were negative indications from Greater Wellington's state of the environment. In what spheres? What are the negatives?
And certainly just starting with the Wildlands report, I mean, table 1 on page 9 shows that between 1996 and 2018, there had been significant increase in Indigenous scrub and scrubland cover in Makara, and also in Karori as well, the suburb that which you just spoke to, but some decline in Kaiwharawhara. So I think even within the Wildlands report, it shows that when you delve down into an area specific assessment, there will be unders and overs. In terms of the Greater Wellington State of the Environment Monitoring Report, the report which I found was one by the Catalyst Group, dated November 2023. it's more pitched at a regional basis. There are some parts of it, and I can find some specific references, I don't have them off the top of my head, where it delves down into a terrestrial Wellington district scale. But being a regional report, it's more focused at that regional level. And quite a lot of the report is spent talking about fauna as well. So I guess in short, I do tend to agree that there is a lack of agreed or a lack of clarity as to what the specific trends and issues may be in Wellington City. Notwithstanding that, I mean, I think that would be a relevant consideration, and as I've highlighted in my rebuttal, for the outside SNA control. But really, when it comes to assessing the provisions for the eco chapter, the NPSIB is a freight train. It tells us what we have to do. And to some extent, whatever the trends are, what I'm seeing that national policy statement is directing is almost to ignore them. And, you know, notwithstanding how great Wellington City may be doing compared to the, let's pick a region, the West Coast or somewhere else. Actually, West Coast is probably a terrible example because they've got lots of indigenous vegetation. That's, yeah. Compared to another region, it almost doesn't matter in the eyes of the NPSIB. It tells you what you have to do. It tells you the avoidance framework. It tells you these activities can use an effects management hierarchy, and really reduces the ability to take a more nuanced approach at a local level. And I've looked for ways to respond to that and to try and take on board the submissions of submitters and tailor that to our context. But I'm seeing that there's not a great deal of room to move. So one of the things I'd really like to secure through this process is some really good evidence from those submitters who are seeking some outside SNA controls or controls which are purporting to stop loss of Indigenous biodiversity, which they're saying is occurring at a great scale across Wellington City. Some more evidence on that.
Like I was, as you were explaining your position, I was thinking, is the answer the instruction to give effect to the NPS as quickly as practicable? What's practicable is might consider what is the urgency also. That the urgency of action might go to practicability.
From my perspective, this hearing process is a very practicable option to take to implement, at least in part, some of the NPSIB, for which there is, as I've set out in my section 6, I believe it is, little room to move, that the regional council is also looking to align itself with. And I guess one of the things I've been thinking about in this discussion to date about reporting back on the regional process, absolutely we'll do that, but I don't think that a lot of my recommendations are totally dependent on the RPS being the vehicle to push implementation of the NPSIB through, and that largely a lot of this stands on its own anyway. It would give me more reason to support deferring bits of the NPS because the regional council's gone not quite sure how to do this, or we can't respond to it right now. So I take some comfort from the bits that they're deferring, that the council, with the Wellington City Council, will not be, you know, pressured or blindsided by the regional council that they're not implementing it because the regional council is not doing it itself. But I do think that this hearing process is a very practicable time to do it. A number of the submitters have questioned using this hearing process to do so. And, you know, Mr. Whittington spoke to the issues of natural justice and the points that Ms. Whitney raised about, you know, changing a policy framework or introducing a new one for outside SNAs at this point. The panel has also spoken about, you know, the change between the notified proposals, and would people foreseeably see a more stringent NPSIB being implemented right now. But yeah, so yeah, my underlying point is I do think now was the time that we should at least take quite some measurable steps to implementing the NPSIB, notwithstanding where if we do or if we don't, I don't think it really matters. I think some of this will be heard by the court. At least we've had the time to try and narrow the scope of issues between submitters and test a number of the proposals which I put forward. Test Mr. Norman and the evidence that we've put forward to judge this.
A number of submitters put considerable emphasis on the resolution of council, and Mr. Whittington's talked to us about that in context of implications for natural justice. And is the reality, in your view, that whatever the rights and wrongs of a council's decision, you come back to the fact that there's a new game in town with the NPSIB, so that the scope to consider, as the council did, there was a need for incentives and assistance, goes by the board, because the NPSIB is saying do it anyway.
Certainly. So clause 3.8 and subpart 2, assessing areas that qualify as an SNA. 3.82F directs that when undertaking these assessments, that artificial, this is the terminology, SNAs are determined without having regard to artificial margins such as property boundaries, and I would also extend that to zoning. Certainly in the eyes of the NPSIB, it does not care for which zone is applied to a property as to whether that should be relevant and it being identified as an SNA in a plan. I think setting that issue aside, yes, my concern is with introducing SNAs at this stage is fundamentally to do with natural justice, rather than there not being evidence to demonstrate that these areas meet the criteria and otherwise have significant Indigenous biodiversity values. It is troubling to me that if they, but given that the framework which we must apply is so tight and so directive that there's little room to move, that if they were to be introduced at this stage, those owners would have no ability to enter into this process. But boiling it down to your question, I think the NPS is very clear. If it meets the criteria, it should be an SNA, irrespective of what zoning that is. And the appropriate time or vehicle to determine that would be through a plan change process, a separate plan change process as it relates to these residential SNAs supported with the appropriate qualifying matter analysis, which we spoke about this morning.
Like what I was actually thinking of was that, as you summarised at paragraph 59, the resolution, sort of talking about an SNA incentives program. And so your subsequent advice is, when push came to shove in the annual plan debate, but bluntly, the water pipes came first. And that's not likely to change anytime soon. So that sort of, it's almost that almost undermines the logic of the rationale of the resolution. It was that there would be a program, and this would enable the city to move forward. And in tandem, you've got the NPS coming in over the top saying don't care anyway.
I mean, I won't comment on the merits of the resolution.
No, of course not. But it's more. It was an intention at the time.
Yeah.
It's been overtaken by other demands.
Correct.
Which happens. Like no one's got perfect foresight.
And certainly I'm not saying that the NPSIB is requiring that incentives packages be established to regulate SNAs either.
In fact, it's the reverse. It doesn't care whether they are or aren't. It's saying do it anyway.
Yeah.
That's my point. That
I agree. Yeah, in terms of incentives or compensations, some of the submitters talked about rates relief, and I just wanted to provide an update that sort of early to mid next year, the council will be required to consult on the rating policy, and as part of that, people will be able to make submissions in respect of rates for emissions and whether particular types of district plan controls should be recognised within that schema. Not saying that they will provide any a solution, but it is a relevant update in respect to those submission points.
Yeah. Do you have any feel? Can you tell us how much of the identified SNAs, like you had a process where you consulted and this part of the draft, you trimmed out some which had been overtaken. Do you have any feel for the extent to which what was previously identified as SNA has either been cleared or is the subject of certificates of compliance to enable clearance?
I don't have a specific sense. I mean, some submitters like Mr. Delija for the Kaiwharawhara Road, Boston Real Estate, I believe is the name, reference a certificate of compliance, which they secured. It was, we did hear after the backyard tonga process started, the consultation started, that people were actively going around and getting certificates of compliance to clear vegetation, but it would have been the minority rather than the majority. I mean, realistically, a lot of people have no intention to clear their backyards, and they won't. I mean, people are free to go and get a certificate of compliance if they want, and they can choose to exercise it or not. But it's certainly, I would say, not the majority. I can understand why those with a vacant residential site close to town would like, well, could see benefit in securing a certificate of compliance. But
sorry, just a question of clarity. Is there a time limit on certificates of compliance?
5 years.
It is 5 years, isn't it? Yeah.
5-year lapse.
Correct.
It's the same as
Same as a
resource
land
consent.
use.
It's
Yeah.
a deemed resource consent, but
Thank you.
yeah, because I'm pretty sure that Kilmarston's they told us that, and
seven natural environment, I think.
but we were both. It was in the context of the SALs, SAL over the land.
Correct. Yeah.
So, but you also heard in Stream 7, didn't you, Lindsay?
Some rezoning issues and around that as well.
Boiling it down, there will be areas which, if we were to run an aerial image over right now, there may be some that don't have bush on them that were identified back in 2019.
But your feel is it's not a lot.
I can't imagine it would be that much.
Like you don't have the sense of just looking around the town of large areas of material areas having been that were in bush are now no longer.
I don't have a sense, but I cannot imagine it is that much. I mean, when my recollections of conversations with those officers who went out and did the site visits during the backyard tonga process was that some people had cleared areas of their backyards, proactively because of these controls coming in, but those would have been 20, 40 square meters, not hundreds and hundreds. I mean, I think it's pretty clear that if you were to stand at Nienville Park in Kandala and look towards, Mount Koko, there's still quite a lot of greenery there, just at a spitballing. So I can't imagine there would be a lot. And to be fair to those owners, probably, as Mr. Whittington noted this morning, the impetus to go and clear it presumably went away from them when council resolved not to notify residential SNAs.
Yes, and we discussed earlier about the overlap between the amount of bush in areas that are subject to HRZ. Would it be possible for you to give us, as part of your reply, some analysis? Like, I'm not saying down to the last, square meter or anything stupid like that, but, some sense of how much of the SNAs, of the land identified as SNAs in the draft is now zoned HRZ. Probably in I was going to say the nearest hectare, but that's probably too defined as well. But the nearest 10 hectares would be enough. Yeah.
Certainly, that's quite straightforward. Yeah.
Similarly, you'd struggle to actually identify those areas of the city which are outside of SNAs.
No,
Well, if you're talking about something with 100 square meters of bush out the back, would you be able to define how many properties are
That were not
which were not previously part of the SNA discussions that the council had before? How many more would there be?
yeah, certainly. So Mr. Norman's analysis that picked up, so take the 100 square metre trigger, every residential site, including those which would have been residential SNAs, every site with 100 square metres of vegetation cover or more, and that was done using GIS and those blobs.
But they haven't been ground truthed at all, have they?
No, they haven't.
No, so
and that's the reason why for the assumption that half it's Indigenous.
Well, yeah, and the quality of the cover as well, what it actually is and what it entails.
Yeah. Correct. So was the question, what's the net difference between what would have been identified as a residential SNA and then what would be subject to the outside SNA control? Gotcha.
Yeah.
Well, I've just written, it was about in the process of writing how many additional properties that weren't addressed and weren't addressed as having SNAs would have Indigenous vegetation.
I'll definitely return with a more accurate figure, but just spitballing, perhaps we can even get that from Mr. Norman's evidence now, noting that there were 1,300 private residentially zoned landowners who had residential properties that were removed for notification, and there are 17,487 affected properties with that 100 metre square trigger. So I'll find the exact figure, but it's probably in the realm of 15,000, I guess. Yeah, 16,000.
That's my questions on the background. Anyone else have in the background section 4?
You've covered my questions, Chair, in relation to the background Taonga project. Just picking up on the incentives issue and looking at the NPS, there may be one exception, or perhaps a few more, I'm not sure, but there's certainly an exception to the lack of provision for incentives in the NPS in relation to the protection and maintenance of Indigenous biodiversity and protection of SNAs and identified taonga on specified Māori land, where local authorities must consider and realise opportunities to provide incentives. Is that something I understand it hasn't, and why it hasn't been addressed in these provisions, but is that something that is specifically intended to be picked up in the Te Ao Māori plan change?
Correct. That would be that clause, which I believe is 3.19 identified taonga. That one is one which I've pegged should go into that Te Ao Māori plan change, and a fulsome discussion had with mana whenua partners around
Yes.
what provisions would they like, and what support or incentives would they see as desirable, and those can be thrashed out through that Te Ao Māori plan change. Initial discussions have been had, not with Ngāti Toa Rangatira or Maupoko to date though.
Yes.
And that plan change is looking, there's a report back which should go back to the Wellington City Councillors for discussion in sort of mid next year. So it's still at the very early stage, but that is a dead ring of what I see should be addressed within there, those
Thank you. So
discussions.
the process is underway.
Yes, yep,
And
absolutely.
that would involve identifying presumably the specified Māori land areas.
Correct.
As well as the taonga, identified taonga as part of that process.
Correct.
Oh, couple. Thank you.
Can you give us a sense at this point, how much residential land would be specified Maori land in the town?
Very little. I can return with exact figures, but I don't, there's barely any. I think the one for which you're going to receive some advice in the wrap-up hearing, the one which might become very relevant for specified Māori land is Watts Peninsula,
Yes.
and what happens with that land disposal process and who subsequently picks up ownership of that piece of land. But that one would be the most obvious example that comes to mind for me.
I was thinking there's also the Island Bay land
Tapataranga.
that we heard from the trust that administers that land
Yeah.
last year.
And also the, because I'm assuming that the specified Māori land would include land that's been returned as part of treaty settlements process.
Correct.
So there are islands as well, potentially, I guess, in that mix. Machu Island, for instance.
I don't think it's in Wellington City.
Is it?
It's in the heart.
It's in the heart.
Tapataranga is. within
Tapataranga,
Wellington.
yes, true. Yeah, okay. And just one more sort of semi-related question. It does relate to tangata whenua involvement in this process. Through my reading of your report, and it may be in there and I may have missed it, but I'm not clear on how the tangata whenua values in relation to the identified SNAs have been determined. Could you just clarify that, please?
So in terms of the identification of the SNAs dating back to 2016, so the Wildlands report was the sort of the key document, that desktop analysis, which primarily used aerial imagery to identify patterns and therefore where Indigenous vegetation and significant habitats would be. So primarily that's been the main vehicle. In respect of additional areas or what values those areas may also have for Māori, Wildlands, I understand, use what information they had available to them to determine if there were any tangata whenua values under the RPS criteria of the time within those SNAs, and they should have been checked with mana whenua partners back, in the draft district plan stage.
Yeah.
I can find more accurate information, but I do not know off the top of my head exactly what that would have looked like.
That was what I assumed had happened, but I think it would be useful to know whether there was proactive consultation with tangata whenua in relation to those identified values, because that is a requirement of the NPS.
Correct.
So that would be helpful. Thank you.
You happy for that pen reply?
Yes, absolutely.
So as we add that to the reply list, please.
It's me.
Lindsay, anything on background before we go on to statutory considerations?
In your 42A, page 20, you talk about SNAs as a qualifying matter, and I know we did talk about that a little bit before with Mr. Whittington, but your para 68 about SNAs would not subsequently function as a qualifying matter as these do not modify a density standard.
Mm.
Can you just outline your rationale? If you've got a 400 square metre residentially zoned property and 100 square metres of that is in bush, therefore that is going to potentially restrict what you can do either as a right or by through a resource consent if it's a multi-unit development. It's going to affect the yield, and so therefore, to me, it would be a constraint on development, as in natural hazard overlays, probably the best example. So, just so I'm clear in my own mind, why you don't feel that this is potentially a qualifying matter?
Yeah, I guess we had a discussion this morning about the percentage of site coverage and how if 60% of a site is covered in an SNA and therefore you can't exercise your 50 square metres of building coverage and your MDRS standard.
50%.
Sorry, 50%. I can see how it could be considered that they are a qualifying matter in that case. For another site, they may not be a qualifying matter because they only cover 9%, and someone can still cover the 50% quite comfortably. So I do find it troubling how it will vary site by site whether it could be considered a qualifying matter or not. At the same time, the provisions as they are now, and as I have recommended, don't go into the detail of saying reducing building height that can be achieved for an MDRS development. They don't lower the maximum building height, or they have not proposed to change the zoning.
Yeah, it's all about the footprint though. Site coverage is what it's going to have.
They certainly are a constraint on development. I'm in violent agreement with you on that point. Yeah.
So natural hazards will be considered as a qualifying matter.
Yeah.
Because you've got a flood overlay over part of your property.
Yeah.
With apples, wouldn't this also apply to 100 square metres or more or whatever of indigenous bush out on the slope above your property?
Quite possibly. I mean, some of the qualifying matter, or some of the natural hazard provisions work in a way in which they don't, curtail that permitted activity standard of the MDRS if you raise your floor level. So they're not, curtailing that or not imposing a development restriction that someone could otherwise achieve under the MDRS. But others certainly do, like the high fault hazard area. You can't realise your 3 units as a permitted activity.
Yeah. Well, apart from ponding areas is the one where you potentially have a permitted activity pathway for natural hazards. But a lot of the other hazards they don't. They're clear. Either you don't do it at all, or you have a fairly difficult process to navigate through to get any consent for development.
I think for the majority of those MDRS standards, you could construct a framework in which they don't curtail the MDRS apart from the site coverage one. That's probably the most problematic.
But the site coverage is going to determine how much of the site you can put buildings on, though.
Yeah.
And if it's MDRS, you can go to 11 metres, and it doesn't matter whether it's 11 metres on 200 square metres or 11 metres on a bigger site. So, but as a site coverage, it definitely kicks in.
Yeah. In the same vein, you could have 3 units, but but on a smaller, on 40 square. It would just depend whether you meet the
the recession plane and various other things do act as development constraints as well to a certain extent.
Is the reality that, taking the natural hazard example, the approach the council took was the one you've identified, which was, and maybe it wasn't a principled approach, not saying that pejoratively, but rather a pragmatic one, that if you're going to evaluate some properties as qualifying matters, you might as well identify evaluate the lot and avoid the need to figure out how many are in each category. If you're like obviously in a 77L category, you do have to consider property by property. But if you're in the natural hazard space and it's just 77J, you may as well take a worst case scenario that everything with a natural hazard overlay is a qualifying matter. And what's the adverse effect? What's the effect of that?
Yeah, so the modelling that Property Economics did undertake for the council, had some assumptions around whether 50% of that entire site was covered in a hazard overlay, what impact that would have on development capacity. But mechanically, like putting them through the plan process, it wasn't distinguished that the mapping on this particular site goes through the IPI and this one goes through the Part 1 process, because the modelling shows that you could achieve the MDRS on that site. That just wouldn't have been pragmatic or practical for the purposes of getting the IPI done, or nor would it be sort of easy to understand for submitters.
And I suppose the question would be, would the smart play be to take a similarly pragmatic view of the effect of Indigenous biodiversity, evaluate the lot as a qualifying matter?
So that has been done, and that's in that PE work. So to cover the base, if you so determined that it were to be a qualifying matter, that work's been done for you.
Well, I think that on the face of it, what you and Mr. Whittington are saying is that it is a qualifying matter where more than 50% of the site is the subject has got Indigenous biodiversity on it, and so that at least would have to be evaluated. And the question is whether it's more sensible to evaluate everything at once than to try and pick out those with more than 50%, when your data is probably not good enough to do that. But that's just me musing. Sorry, Lindsay, I diverted you.
I don't have anything further with the intro. Thank you.
Okay, well, we'll go on to statutory. Let's write this down. Give me a moment. First question is, I think I found an error, I have to say, in a 240-page document, McCutcheon, which is a credit to you and your colleagues. Paragraph 83C. So B says within 8 years, 2031. C says 5 years, 2031. So it does not compute.
They're quite troublingly worded as well. I found those implementation timeframes.
So that should be 2028. And going on to your discussion about the fact that the NPSIB has a carve out for the national grid. It also has a carve out for REG. What's the effect of that? Does that mean that if you're not implementing the MPSIB in respect of National Grid or REG, there are no Indigenous biodiversity provisions in relation to those. And if there are, what's the source of them?
So this has been,
Or the underpinning of them?
yeah, so I mean, this has been the subject of discussion between Ms Whitney and Ms Foster and Mr Jeffries and myself. And you'll receive some advice on this issue in the wrap-up hearing, but my view, and as Mr Jeffries' view as well, does not mean that biodiversity and significant Indigenous biodiversity values are to be disposed with to enable the national grid or renewable electricity generation to occur. Councils still have an overriding requirement to manage those effects under the RMA more generally, and as well, and also in the regional policy statement. So it's not that those values are to be put in the bin, it's that from the outset, the policy direction and the directives of the MPSIB do not apply per se. So you could come to the conclusion that an effects management hierarchy approach would be defendable and would be appropriate to manage the effects of renewable electricity generation on significant natural areas, but that would not be a construct being directed by the MPSIB, rather a conclusion that you would end up at having considered the most appropriate planning provisions to reconcile those tensions.
So it's an if it becomes, in King Salmon terms, it becomes a gap. The NPSIB doesn't apply to the national grid. There is a gap. You would then look to the NPSET, and if that doesn't cover it, you would, well, or the NPSR REG, if that doesn't cover it, you go back to 6C ultimately. And it was subject to what the RPS might change, but that if the RPS is shifted to implement the
so yeah, that's when I Mr.
IB.
Yeah, when Mr. Jeffries and Mr. Anderson would turn their minds to how does the RPS reconcile, not through plan change, probably not through plan change 1, although it may be, but not directly to implement the MPSIB, but in the first instance that probably addresses that tension. Then again up to section 6, as you've noted.
That's an issue that both Ms. Foster and Ms. Whitney have addressed in the evidence they pre-circulated for this hearing that we've directed that will go off into the wrap-up hearing. But I don't think they disagree with you.
No,
it might be they might have a different view as to what those provisions.
Correct.
But I don't think either of them are saying there should be no provisions.
Just on that, so if there is a hypothetical or probably fanciful fact scenario of a hydroelectric scheme covering the entire area of Macra, the MPSIB does not come into play at all. Is that your understanding of the position? There's nothing in there because it would automatically go to 6C and what's in the district plan provisions.
So if that scheme were to fall within the definition of specified infrastructure,
can't imagine you get many megawatts out of the Macra Creek.
Generation of electricity. So if it were to fall under the definition of infrastructure, either as a lifeline utility under the CDMA or the RPS is regionally significant infrastructure, which it probably would if it were to be newly constructed, the INF Eco chapter would be engaged, not the Eco chapter proper.
Yes, no, I understand that position, but the MPSIB implementing the MPSIB doesn't factor in any decision making at all?
No, so the MPSIB still does apply to specified infrastructure
Yes.
in respect of things that step outside of operation maintenance and upgrading with no effects. They kick in, as do so specified infrastructure does get subject to the MPSIB. It's just that the national grid and the renewable electricity generation activities are not subject to it, but can still be managed to protect significant Indigenous biodiversity values.
Yeah, thank you.
So I think the answer to your question is yes, the MPSIB doesn't apply, but yes, but there would still be controls. We need consideration of controls. Looking at the table, you have your table 1, which is very helpful. Thank you. Putting it in this format sort of made me think about some of the issues about MPSIB and implementation. And I was thinking about policy 4, promote resilience to the effects of climate change. And I was left thinking, how on earth can the district plan do that?
I also found that problematic from a policy sense or a rule sense as well. So where I ended up, my table 3 shows the cascade between the MPSIB, what the PDP does now, what the regional council has done, or the reporting officer has done in RPSPC1, and then my subsequent recommendation. So following that through, all that I recommend to address this, as I do find it problematic as well, is include a non-statutory method, which is promoting the resilience of Indigenous biodiversity to climate change.
So the answer is nothing meaningful, nothing in a regulatory sense that you can think of.
Nothing in a regulatory sense that I can think of.
The State of the Nation with change 1, I think Commissioner Schofield flicked me a communication he'd seen gone past, said that decisions would be 26 September. Is that your understanding?
That is my understanding.
Talked about how we'll deal with that. So going to table 2, I appreciate that this is the regional council's position, not necessarily your position, but go to policy 10, where the recommendation is give effect in part. Why only in part? Policy 10 and clause 3.5.
I'm just going to pull up that reporting officer's comment on that one. The reporting officer considered that the notified RPS PC1 gave effect to it in part, and the main gaps in relation to policy 10 were in relation to direction to provide for activities that contribute to wellbeing, and that protecting Indigenous biodiversity does not preclude subdivision use and development in appropriate places.
Can you slow down? Just
Sorry. So the reporting officer considered that the notified plan change 1 to the RPS gave partial effect to that policy.
Yep.
And then their recommendation was that no additional amendments are made to the change 1 provisions to fully align, but it was not discussed why those changes should not be made. So that reasoning is available at my para 101. And that takes you to that reporting officer's, you need a laptop to have a look at it, assessment on page 9 of their table. So I think their point was that it doesn't, you don't necessarily need to go and change content in a plan to do that, to recognise the social, cultural, environmental benefits, but that your plan provisions should inherently do that, or you'd follow a process to recognise the social, economic and cultural wellbeing. So for example, in this district plan, the new permitted standard for enabled clearance around a quarry would recognise the economic benefit, economic wellbeing through enabling a level of clearance that does not have significant adverse effects on biodiversity.
Okay, thank you. Going on to the amendment bill, your discussion of 78, clause 78.5. Had a discussion with Mr. Whittington on the subject. I was interested about the language. You're saying an area is included in a policy statement. How is an area included in a document? Do you think that means mapped or describes?
Which paragraph?
Sorry, 109.
Yeah, that's my understanding, and I guess it's kind of legislative language for doing what a district plan would do.
Because what I'm thinking about is whether the rules you proposed, what you've described as Indigenous biodiversity outside SNAs, might be described as an area which is included.
I don't, off the top of my head, and I'll let Mr. Whittington jump in as well, but in the first place, I don't consider that they are significant areas of significant Indigenous vegetation by virtue of them not being mapped, the outside areas, as SNAs in the first instance and included in the plan.
Like hence my starting point. It's the mapping which is the key. Because of course they have previously been
Mm.
just categorized as qualifying as such.
Yeah. Yeah.
So from your vantage point, it's the mapping which is key.
Correct.
Yeah, and without having seen any recommendations from, in terms of the RPS, do you know if there is extensive mapping of biodiversity values, or is it just down to words describing what is to be mapped at the lower level plans?
I mean, in terms of the policy directions, it just essentially replicates the directions of the MPSIB that TAs go and do the work when you meet the criteria. So the first trigger is that councils need to go and do the mapping fundamentally. That document, I think it might be actually the NRP, has a separate schedule of primarily, I think it's terrestrial and freshwater. Significant Indigenous biodiversity areas
And coastal too.
and coastal ones, But yeah, the first trigger is for TAs to do the work to identify spatially. I'm sure we'll hear to some of the challenges about when things aren't mapped, how rules apply later on.
Yeah, and then I'm sure we'll have some discussions about how you define the 100 square meters and the values that need to be included as well.
Yeah.
Where it is and what constitutes the 100 square meters, if that indeed is the figure.
One of the options I toyed with was making a recommendation that the layer which is available to yourselves on the viewer, i.e. the unidentified residential SNAs, be identified in the E-plan as areas which are likely to trigger the outside SNA rule. But I stopped short of making such a recommendation on the basis that I thought it would add confusion and create confusion in that those areas may not, well, there will be, as we've discussed this morning, 15 to 16,000 other possible properties which would also be potentially subject to that rule. So it would be only in partial recognition and might set people up to fail and set up non-compliance with the rule inadvertently.
The other thing is that given what was 78.5 now says it probably wouldn't be a good idea to be mapping anything more. It might have effects that you didn't intend it to have. Paragraph 114. And this is in the context of the MPSFM, the NESFW, no natural lakes. And I was left thinking, well, I'm not sure that the NPSFM distinguishes between natural and unnatural lakes. It only distinguishes between natural wetlands and other wetlands. So, I can think of, well, obviously there are the two unnatural or artificial lakes in Zealandia.
Correct.
I'm not sure if there are any others,
to my knowledge.
So, presumably, there are so many protections hemmed in around the Zealandia site that we don't need to be concerned with MPSF FM
That was my view.
implementation. Okay. Then we move, anyone else on section 5? Oh,
I'm going back a little bit, but that's all right. I didn't want to interrupt your flow. I'm just conscious that the implementation of the MPSIB, has a process to follow, and you've proposed some changes to provisions, and I just want to understand a certain part of the implementation process and whether or not or how that was followed. And this is particularly to do with tangata whenua issues. There's the clause 3.3, which sets out a particular process. And I know the councillor are embarking on a plan change process to, if you like, deal with those issues. But what I'm trying to understand is the changes that you've made. How have tangata whenua been involved in those? And how have you assessed whether or not there is an impact on their values, knowing that you haven't followed the full implementation process?
So you are correct that I have not followed the MPSIB process for engaging with tangata whenua and following those decision-making principles and coming to the recommendations that I have now.
Yeah.
I have not engaged with our mana whenua partners on that. One of the ways I did turn my mind to what impacts there could be on mana whenua and their aspirations was looking through this, or responding to their submissions, and whether I was making recommendations that were the inverse of what they were asking for. And in many cases, I did take up the relief that Ngāti Toa, who made a number of active submission points on this chapter, were asking for in respect of customary harvesting and the ability for mana whenua to undertake restoration and protection of Indigenous biodiversity. But I have not engaged separately with mana whenua on my recommendations, and I do recommend that occur fulsomely for those provisions that have been deferred.
Sure.
At the same time, that process, that Te Ao Māori plan change process, could also turn its mind to whatever provisions eventually get confirmed in this process and identify if any need to be amended through that discussion as well.
So there's an opportunity, if you like, to backfill.
Correct.
Yeah.
Yeah, I would see that as the role of that Te Ao Māori plan change as well. And I think the timing will work in settling this and then turning our mind to it throughout the process of engaging with mana whenua as to how or what should be within the scope of that Te Ao Māori plan change.
And so what's the time frame on that?
Yeah, so the plan, as I understand it, is that council officers will report back on where discussions in respect of scope have got to with mana whenua partners in mid next year. So the first step of it will be working through what's actually in this plan change, which will then necessarily dovetail into a number of sessions as determined by mana whenua, how they would like to run them and who should be involved as to what those provisions should eventually say. Obviously, we'll have to go back to council to get agreement to notify, and so there will need to be some information exchange at that point in time.
Yeah.
But it will be likely that it won't be until 2026 that
Notified in
plan change would
2026.
eventually be
Yeah.
notified. So in that way, the full ambit of this proposed plan should be within scope because it will have been settled before the time that plan change is notified.
Okay. So you don't see any particular risk at this stage with the provisions that you're changing, knowing that you haven't had direct involvement?
I don't. I've been very cautious and careful to make sure that I have not made recommendations that may have impacts on mana whenua for which I haven't engaged with them. So for another example is the Victoria University Students Association made a submission wanting reference to Rahui put into a policy, and I noted that neither of our mana whenua, council's mana whenua partners had commented in a further submission sense on that. So I didn't feel comfortable to take it forward, even if I had thought that there'd be merit in their submission point.
Sure, thank you.
Yeah, go.
Yoda, just to follow up on that question, and to maybe put it another way, and accepting what you're saying in relation to the risk potentially of not having fully addressed these mana whenua issues to date. When in your opening statement this morning, you talked about the need for the panel to be mindful of and consider whether achieving objective 1 of the NPS IB can be achieved through the provisions that can be confirmed through the district plan to date. You don't have any discomfort or concern around the ability of the provisions that we have in front of us to consider and make decisions on that don't include, to a large degree, the intended policy and objective sort of framework anticipated by the NPS around tangata whenua issues. You don't have any discomfort from a planning point of view that we might be in a position of risk in terms of achieving and meeting the objective 1 of the NPS. Just wanting to, I haven't asked that very well, but I think you get the gist of where I'm coming from. And I just wanted to make absolutely sure that from your perspective, there's no risk to the panel in being able to meet the requirements of the NPS and achieving that objective through these provisions that we have in front of us, bearing in mind that there is still a significant future plan change process to occur.
So I don't think that the provisions which I recommend will give full effect to Objective 1 and in all its parts, which include at clause 1B1, recognising the mana of tanga whenua as kaitiaki of Indigenous biodiversity. I don't think these provisions will do that.
Yes.
Because we have not engaged on that process with mana whenua. And I've noted that I don't think Notified Eco 04 fully does that either.
Yes.
It's sort of passive in its phrasing rather than assertive, and the role that mana whenua want to take as kaitiaki of Indigenous biodiversity. So with the best will in the world, I don't think that we will achieve Objective 1 in full.
Yes.
But not to say that the process shouldn't be used to try and work towards their supplemented by additional work through that Te Ao Māori plan change in recognition of the deficiencies in respect to mana whenua engagement.
Yes. I mean, do you think that this hearings process, in terms of what we can consider, will give sufficient effect to the NPS IB at this stage in the process?
In terms of the NPS IB generally, I think, my view is what I've recommended in terms of provisions to implement in part or full now is appropriate in the journey to implementing the NPS IB. We're not implementing it in full now. But I think what I've recommended is appropriate for this point in time to be supplemented by additional plan changes in the future to bring it into full compliance.
Yeah. Okay, thank you. And just in terms of that earlier request we made in relation to clarifying the any consultation that may have been undertaken with mana whenua in relation to the identification of cultural values related to the identified SNAs. Would you please be able to provide the panel with a full update, if you weren't already planning to do this, on where work is at in relation to the Te Ao Māori plan
Certainly.
change process and those timeframes that you discussed earlier with the Commissioner, and also particularly in relation to matters relating to the provision of papakainga housing and other matters of that nature that might be affected by the NPS IB requirements.
Certainly. One of the things I'll report that back in full. One of the things I can do in the interim is that in 3 days' time, the council will be receiving an update from officers on the progression of the Te Ao Māori plan change, and there is a paper to that effect detailing what has been done already and the timeframes that would apply. So I've just pulled up this this paper, and I can have Marcella share the link with yourself so you can read it in full. But what the update in that paper says is that initial hui have been held with Port Nicholson Settlement Trust, Taranaki Whānui and hui with Ngāti Toa Rangatira and Mopoko are currently being scheduled, and it talks to those timeframes. So I will look to provide you some more detail, and I can share
right of
that.
reply as well.
Yeah, certainly.
Thank you.
Anything else on section 5, Lindsay? Well, we're slightly early, but I don't think we want to get into spend 5 minutes talking about reconciling national policy statements. So we'll break for lunch and be back at 1:30. restarting the Stream 11 hearing, talking about reconciling national policy and regional policy direction. We're clear that nothing the government has done, or the new government has done to date, alters the legal framework within which we're operating. Talk to you about the essence of your section 6 discussion, starting at paragraph 153. I suppose the starting point is a question of principle. Referring us back to section 5, and I wanted to, and the concluding statement in paragraph 154, maintenance of Indigenous biodiversity needs to be considered within the context of the overall purpose of the RMA. So what I wrote in my margin is that a correct statement of law? It's my understanding of combination of, or the Supreme Court's guidance to us, is you might end up back at section 5, but there's a long way to go working with the NPSs you have before you have the option of seeking guidance back from section 5.
Yes, my broader point is that, in my perspective, in reconciling the NPSIB and NPS-UD, the approach that we should take is one in which Indigenous biodiversity in urban areas the management approach which we choose is consistent with the sustainable management purpose of the Act. So it's about finding that balance of enabling urban development, the creation of well-functioning urban environments, while still endeavouring to achieve Objective 1 of the NPSIB and the maintenance of Indigenous biodiversity. That's the lens in which we should take to developing objective policies and rules in this plan.
Firstly, the message I took from the Port Otago case was you need to work and make sure that you actually have an irreconcilable problem before you have the ability to do that. And do we have an irreconcilable problem as between the NPSIB and the NPS-UD?
Probably my take on the problem that we would have is that we have a very directive, protectionist NPSIB compared to a very enabling focused NPS-UD in the way in which those language directives or ones which are more focused on enablement, has typically been treated as that the more directive protectionist one, the avoid one, has carried a more directive and given it applied a greater weight, such that sets up this conflict between an enabling NPS UD, which we need to reconcile.
Does that come back to the point we discussed earlier, the extent to which Indigenous biodiversity is present in high density zoned areas? Like that's where the direct conflict arises. It's more indirect with the medium density areas.
I'd still say that there is a high level of conflict insofar as those medium density areas are quite pivotal to achieving the development capacity, which the plan, which the council was required to achieve under the NPSUD. And I think Mr. Norman's analysis of the impacts of the proposed outside SNA control speak to how significant that control could be in respect of development capacity, even outside of those high density areas. But I do agree with you, Chair, that there is a direct conflict between those not so much a greater conflict, but a different type of conflict where policy 3C of the NPSUD is directing some pretty intensive outcomes, which for us so happen to overlap with areas of at the moment unidentified areas of significant Indigenous biodiversity.
And as the discussion the question I asked Mr. Whittington, he agreed, well, protecting Indigenous biodiversity is part of a well-functioning urban environment. And is the area of reconciliation in deciding how much protection you can give to Indigenous biodiversity and still achieve the objectives of the NPSUD? Is that what this is about?
So certainly at that strategic level, the strategic direction in the UFD, so the Urban Form and Development chapter of the plan, align with your point that the creation of a well-functioning urban environment includes one that is ecologically sensitive. So there is compatibility there. I think with the directiveness of the NPS IB, it's really at the margins where we are able to influence or take a different approach to the protection of significant Indigenous biodiversity. And that's because the NPSIB is so directive. It sets up an avoidance framework where only a specific number of specified activities are able to use an effects management hierarchy approach outright. And at the margins, it's those effects on Indigenous biodiversity outside SNAs where councils are directed to manage them consistent with the objective and policies of the NPSIB, where I have seen there is the greatest ability for us to reconcile the tensions between these two pieces of national direction. Outside of that, I don't think there's a great deal of ability for us to do anything particularly innovative or to meaningfully reconcile that tension, because the NPSIB just does not allow us the scope to do so.
I suppose the essence is, you put it somewhere else I was going to ask you about. You need to look at the NPSID through a NPSUD lens. And the question I was going to put to you in that context was, why don't you think about it in the reverse? Why aren't we thinking about giving effect to the NPSUD through an NPSIB lens?
I'll go back to my point where I think that the only area where there is the ability to take a direction either which way of implementing the NPSIB through a UD lens or a UD1 through an IB lens is where it's not specified within the IB because it is so directive. And the only place I'm seeing that is through the outside SNA control. Otherwise, it's so clear that no matter which sort of philosophical approach you take, you have to avoid adverse effects on of a specified range of effects on Indigenous biodiversity. Other effects can be managed through the effects management hierarchy. It's so black and white.
And so just on at 316, new development outside an NSA, any effect on Indigenous biodiversity outside SNA must be managed. Any significant adverse effects must be managed by applying them. Which gives, as you say, gives quite a bit of leeway. First of all, there's the out from using the effects, but you're also looking at significant adverse effects. What is a significant adverse effect?
Yeah, so in my rebuttal, I've identified that I don't think a significant adverse effect is strictly tied to the amount of vegetation being removed. It could be really high quality, rare Indigenous biodiversity that even a small amount of removal may result in significant adverse effects. So this identification of what might be an appropriate trigger has led to me recommending both an area-based trigger and a size of an Indigenous tree trigger. So that's the discussion in respect of that outside SNA control. And they are proxies, they are but proxies. It may be that 50 square metres of removal of a particular type results in adverse effects that should have been managed. But the most that we can do is set up, based on the best evidence of the problem and an appropriate ecological response, a trigger to require consideration of effects, whether they be significant or just otherwise adverse effects, through the resource consent process informed by ecological advice.
And I suppose you can only use tree diameters outside the urban area.
Correct.
And so you're down to size.
Correct. And so this, I guess the vagaries of 3.162 is what I have taken to reconcile the NPS UD and IB through submission scopes such as Steve West, who has identified this very tension himself. And I consider that it needs to be addressed at an objective level in the first instance, which is why I have recommended the addition of a new objective on this very matter, recognising an urban environment and the protection of Indigenous biodiversity outside of SNAs.
Okay, looking at your reasoning at 158, the last part saying, well, maintenance of biodiversity outside SNAs wasn't identified as a qualifying matter in the IPI. Provisions of the Eco chapter therefore needs to be carefully considered against the presumption in favour of urban development. I thought that it went through my mind was that, well, it couldn't be considered through the IPI because the NPSIB post-dated notification and sort of partway through the IPI process. And we now also have the overlay Waikanae land, which the High Court have just told us is is the required position. If we have new constraints, they can't be in the IPI process. So maybe more by luck than good management, we've ended up in that position that if we're going to consider it at all, we're considering it now in the first schedule process.
Mm.
And so is the question more not whether we could have, but whether we should now?
Well, I guess speaking to your point of timing, the IPI is done.
Yeah, it is what it is.
It is what it is, but we still have this overriding requirement to reconcile these two pieces of national direction. I recognise that this statement is another example of the one which you pointed out earlier. I could have worded this, the standards for urban development and the creation of a well-functioning urban environment need to be reconciled in light of the need to protect significant or otherwise Indigenous biodiversity. Rounding back to my point, though, I have accepted that the NPSIB is so directive, and I have not, taken to challenging, for example, the requirement that significant adverse effects outside of SNA should be managed by the effects management hierarchy. So it's only at the fringes that we can reconcile this presumption in favour of urban development set out in the NPSUD.
Okay, your paragraph 160, that the NPSIB has the potential to have disproportionate and disenabling effect on urban development within existing urban areas if the objective is applied in an unfettered manner. Is that the test? Should the test not be the one in section 77J, or the series of tests in section 77J? If it's going to constrain urban development, then it needs to be evaluated. Then that evaluation is the reconciliation.
I agree that for some sites, as we discussed earlier, it may be an issue because it limits the site coverage standard of the MDRS, but for others it may not, and then it isn't a qualifying matter nor required to go through a 77J assessment. So I think there is variability in whether 77J is the primary test for assessing these controls and when it is not. I think the part of the reason I've put more broadly why I don't think it should apply in an unfettered manner is for the reasons set out in my 42, where I talk about I don't think that there should be a one tree in, one tree out approach trying to reconcile UD with IB when it relates to effects on Indigenous biodiversity that otherwise aren't significant. They are just they are less than significant effects, which has set out my approach to go down this minimise pathway. And we had a good discussion about minimise earlier this morning. I'm sure we'll continue to have a good discussion about minimise, but that's where I'm trying to nuance. So I've tried to set up a more nuanced approach to what maintaining Indigenous biodiversity so there's no overall loss within an urban environment where there's unidentified Indigenous biodiversity, where the effects of removing it for urban development may not be significant. So it's really at the bottom of the funnel where I'm trying to reconcile this tension between IB and UD.
Suppose the question might be, if control on Indigenous biodiversity isn't sufficiently material to require a qualifying matter analysis, should we presume that it's not inconsistent with the NPSUD? Because that's the mechanism that the NPSUD established, and the legislation wrapping around the NPSUD established to, in effect, protect the integrity of the NPSUD.
I think that would be,
and only depart from it in appropriate circumstances.
I think that would be a fair conclusion to reach. I mean, part of the my logic to including 100 metre or recommending 100 metre clearance as part of the outside SNA rule is to enable development to continue. After which, that if you can't meet those permitted standards, you go through that consent process, which is still more enabling than had that area been within an SNA. That's the part of the reason why I also asked Mr. Norman to consider or to assess different area-based thresholds, so we could see how this balance of UD and IB would shift throughout changing thresholds of clearance. So I do think that that is a fair assumption to make. I also note that even with my proposal to allow 100 metres of clearance, there still could be significant adverse effects on Indigenous biodiversity. I'm not saying that this is, the golden rule that will ensure consistently there will be no overall loss of Indigenous biodiversity. I think the only way that you could probably do that would be removing anything would require resource consent, and that's just not practicable, nor feasible, nor justified. So even under a proposal where a nominal amount, say 100 metres of vegetation is permitted to be removed, there could well be adverse effects on Indigenous biodiversity. There probably will be.
Any questions on section?
Sorry, just to follow on from there, sorry. So do you think that your approach is likely to lead to unequal outcomes between the UD and IB? That's sort of what I'm hearing you say, that it's unequal. I know that the plan doesn't give full effect too, so I have to keep my mind to that. But the way you're progressing, that appears to be the flavour.
Well, I think it's reasonably clear from Mr. Norman's evidence about the impacts of development capacity of the control as he's modelled, even with those bigger thresholds, still results in some significant impacts on development capacity, such that there could be issues for the council in meeting its development capacity targets, pending providing some further advice around the specifics of slope and how that was addressed in larger sites. There appears to be some significant impacts on development capacity, such that you could come to the conclusion it was favoured and it was favouring IB, Indigenous biodiversity protection. I think what will help us answer this question is receiving some clear advice from the ecologists around, are we able to meet our obligation or our requirement to ensure that there's no overall loss of Indigenous biodiversity.
Well, while you're on that subject, I was going to ask you this in the context of the specific wording. Of course, the NPS objective, no overall loss, is nationwide. Have you made a leap translating that, a nationwide no overall loss, to a city no overall loss? Is there at least an argument for an unders and overs approach? Like in the NPSFM, famously, it uses an unders and overs approach, and that's been, well, as between waterways. And no one's thought a lot about that, although the document clearly provides for it, because of the difficulties of enforcement and assessment and a whole range of other things. But you've made the leap that if Wellington City's not achieving an overall balance, overall maintenance, you're not achieving the objective of the NPSIB.
Mm.
The question is that right? That, like, for exactly the reasons you've identified, with sort of direction for urban development, might suggest that the non-urban areas who don't benefit from the same countervailing NPS direction need to pick up more of that obligation than the urban areas.
So I guess it's the nature of NPSs that they are set at that national level and speak from the throne, as it were, about what outcomes should be achieved. I would have hoped that if the government had seriously intended for this biodiversity unders and overs approach to be addressed at a national scale, that it would have promulgated planning provisions to do so. Be it through a national planning standard or some other mechanism that councils could just put them into the plans, that the government was satisfied that it would overall on balance for the country work, rather than let TAs and mandate TAs in respect of 3.16 in particular. Clause 3 says every local authority must make or change its plans to be consistent with the requirements of this clause. So they have directed each TA, each local authority, develop planning provisions which, with all the best will in the world, will not be coordinated across councils to address this issue. I think there's also the fair point that local variation is always needed. I mean, we may get to the point in this hearing with hopefully some evidence appearing as to the nature of this actual issue and trends in biodiversity in Wellington City, that we don't actually need to change the framework of this plan to do anything in respect to 3.16, but other TAs may do, because of local trends that, if we pursue this line, that there's it should be undertaken on a national basis, because local trends are working counter to the protection of a particular type of biodiversity at a national level.
Like, I suppose the thing that put that in my mind is that you put so much weight on that. Are we going to ensure maintenance within Wellington City? And the question is, does the NPS push you that far? It certainly means you couldn't compromise the overall management or maintenance, and in terms of, well, you'd hope they would have made that clear. I think if we want to write a book about the deficiencies about how this NPS is written, it might be quite a lengthy tome, starting with the extent of the evaluation, but that's not our role. We don't have that right, and it wouldn't matter if we did. The legislative message is effectively to suck it up and take it as we see it, rather than as we might hope those down the road who come up with these instructions might have thought about it. But as I say, if we're going to get literal about it, is a local authority by local authority maintenance position what the NPS directs?
I mean, I think it's quite clear that objective 1A says that the objective is to maintain Indigenous biodiversity across Aotearoa New Zealand.
Yeah.
So that is at least pitched at a national level. But I think the only way practically that you could implement it is at a local, in respect of a district plan, is a district plan local authority, territorial authority level. it doesn't stop councils working together to perhaps, develop consistent planning provisions across territorial authority boundaries that, take an integrated approach as the NPSIB directs to the maintenance of SNAs where they cross what are artificial in the natural world anyway, SNA boundaries. But I think practically, in absence of any, regional strategy or direction from the RPS about how to reconcile this, and it's directing territorial authorities to do it themselves as well. In absence of any regional coordination, this is the only way.
And yes, by group. So in effect, your reasoning is the same, that it's caused, I think, the general approach to read down reference to overall results in the NPSFM context. Like, good idea in theory, you can't make it work.
Yeah, and that's why I've pitched new Eco 01 at a Wellington City level.
Yep. Sorry, Liz. I climbed it again. Lindsay? Sorry.
I do have one more. I know this is backtracking a little bit to our discussion before. We were talking about mana whenua involvement. You didn't mention it at the time, but I know in here you've talked about the reliance on the strategic objectives provisions that specific to Māori relationship with natural environment, shall we call it. So I just wondered how they are how that works on a day-to-day level. Because you're placing a bit of reliance on that to ensure there's no risk, if you like, in the meantime. So I'm just wondering how that plays out day to day. Like how are those two directions going to be employed when somebody's going to be making a decision on a consent, for example?
In respect of the clauses of the NPS which I haven't recommended be implemented, or the strategic direction of the plan?
So the clauses that you've recommended not to be included yet. Yeah.
I mean, I acknowledge it until the work is done through the Te Ao Māori plan change, which will be able to have the scope of revisiting whatever gets settled now, as well as what has been working through what has been recommended to be deferred, if that's where the panel agrees that should be. There will be a period where mana whenua aspirations may not be realised because they haven't had the chance to voice them to me, because I haven't engaged with mana whenua in this part of the reporting process. So I do acknowledge that. I think there may be some overlap between things like the sites and areas of significance to Māori provisions and where consultation requirements are triggered in respect of SNAs that happen to overlap with those sites. But more generally, there could potentially be the opportunity through if a consent is publicly notified, there are no public notification preclusions on the SNA Eco R1 rule for input. But by and large, it's been left unreconciled and should be reconciled through the Te Ao Māori plan change process. I think it's also important to note that even if we did nothing, those tensions would still be unresolved until more fulsomely addressed.
Yeah, I understand that. I know you did talk about reliance on those two strategic objectives. So I just wondered in reality how that plays out, but you've clarified for that. Thank you.
Right. Anything on section 6?
No, thank you.
Lindsay?
Yeah, just one, and the chair referenced your paragraph 160 about disproportionate and disabling effect on urban development. If that in MPSIB objective is applied in an unfettered manner, in terms of fettering it rather than applying it in an unfettered manner, the range of options are do as little as possible through to doing quite a lot. And we've heard from Dr. Norman about what doing quite a lot might mean in terms of development capacity. Are you quite comfortable you've had a look at the complete range of options that there might be? Like you've got a very comprehensive 240-page section 42A, but is there any way that you can foresee that you could meet the intent of that objective, but having a slightly impact upon development capacity? Got the 100, 200, 300 square metre limitations as being one, but is there anything else from our discussion so far this morning? There might be.
Guess what you could say I've weighed and considered as the non-negotiables are that avoid framework and the effects management hierarchy for those activities that are so fortunate to be able to fall into that bucket. That is so clear within the MPSIB. I've taken that as a non-negotiable. The only bit where I can see that there is that flexibility, as Commissioner Dace has identified, is in that outside SNA space. And so my rebuttal, after seeing the results of Mr. Norman's work and what potential impacts there could be on development capacity, I have turned my mind again to what those alternatives could be. There are certainly alternatives which I think that we can, the panel could come to the view that were appropriate, being a lighter touch option, or and still in fulfilment of the directives of clause 3.16 and set the plan up to achieve objective 1, only if we come to the conclusion that Indigenous biodiversity can be maintained in the absence of additional plan controls. So they would be things like using what discretion there is within the earthworks rules, within the subdivision rules, to place conditions on consent to manage Indigenous biodiversity values that may be found on a site, through things like the setback provisions that apply to riparian margins, and assuming that there's Indigenous biodiversity, there may be within some of those spaces. What assessment criteria there are, giving the ability for consent planners to impose consent conditions to manage effects on Indigenous biodiversity.
Like what?
For example, some of the earthworks rules have assessment criteria about the removal or the replanting of Indigenous biodiversity as a method of stabilising a slope after it's cut.
Yeah.
So it's all very minimal stuff.
Yeah. But some of those conditions, somebody's wanting to build a number of residential units on a relatively small site, and half of it is covered by bush of some description. And the proposal is either we get this amount of units or a lesser amount of units if the bush remains. How would a consent planner, but and we're probably talking about some of the detail which is going to come up in the rule framework and the assessment criteria and so forth, but how would a consent planner deal with that, saying I cannot achieve my permitted 3x3 on this because there is something like there's a big trunk sewer or something like that which runs through the middle of the site which says this is a no-go zone? How would a consent planner be able to deal with something like that, which is ultimately reasonably subjective?
In respect of Indigenous biodiversity effects.
In respect of Indigenous biodiversity.
Yeah.
particularly when you've got a potential for a blanket rule, which is going to apply, and whether it's 100, 200, 300 square meters.
Mm.
But when it comes down to a consent being triggered for that.
Yeah.
You've got an ecologist which says, oh yeah, it's quite good.
Mm.
And the developer's saying, well, you're fettering my.
Mm.
So this is why I'm trying to explore, is there options for a lighter touch
Yeah.
in terms of the regulations you're proposing, particularly R4?
Mm-hmm. Yeah, I mean, the tension that you identify and how a consent planner would weigh this, that's the same conflict or the same process through which, heritage evidence is tested and weighed by an applicant's heritage advisor, the council's heritage advisor, and ultimately that resource consent planner makes the call. I mean, I've noted in my rebuttal and in my 42 that the MPSIB has pushed us down an effects-based route. Fundamentally, that's what it is. It's, are you avoiding these types of effects? And in respect of the outside SNA control, are you having significant adverse effects? And that will be a case-by-case basis, unfortunately, based on the quality of that vegetation or how significant it is to a particular type of fauna, how rare it is. It will vary. And so there's probably not much comfort that I can offer about how.
To me, the correlation then there might be with a heritage building doesn't quite fit, because a heritage building, it's been nominated on the basis of detailed individual research about what the heritage values of that particular building would be. And if you want to demolish it or partially demolish it or build an extension to it, then you've got something to go back to. If you're looking at potential for there's a site in Nio, for example, 600 square meters, half of it's covered by bush at the moment. You want to 600 square meters, up to 50% site coverage. You could theoretically have 300 square meter footprint on that for buildings. You're not going to be able to achieve that. And what you're assessing it at a resource consent level is going to be the values of that particular piece of Indigenous biodiversity, what it might be. But you don't have that detailed assessment of what those values are and the reasons for it in the plan. And that's the problem that you're going to, one resource consent planner might deal with it differently than another. I know we're at the fairly early stages of this hearing, but this is what I often think about: real life scenarios and how they're going to be implemented and how they're actually going to be processed by the reporting planner too.
I do too, and that's why I find it problematic.
The sharp end.
Yeah. And that's why I find it problematic that there is this directive to manage any significant adverse effects through using the EMH hierarchy. But for that 600 square meter site, it might so turn out that there are no significant adverse effects that would be created depending on that type of bush and whatever compensation or offsetting scheme that an applicant puts forward. So there is a consenting pathway. I agree that at a high level it is not super clear.
But some of those options for compensation might not be able to be applied anyway. Because that residential property owner has only got control over their own land, and if some of the compensatory items mean that you've got to plant somewhere else, you've got to go to a third party, so it just doesn't work.
Speaking to the assessment of alternatives and what those lighter touch options could be, I might add that the reasons which I discounted them were because things that we've locked in the plan at the moment are sort of separated from a purposeful trigger. So I talked about how there potentially could still be the ability for there to be significant adverse effects even through moving 100 square metres of bush. If we're relying on the scattered matters of discretion and assessment criteria throughout the plan, there may not be a trigger at all that achieves that requirement for managing significant adverse effects. through the effects management hierarchy if a resource consent is not required in the first place. Similarly, those controls weren't developed for this purpose, for implementing 3.16. And also they're not certain for plan users or resource consent applicants at the time of lodging their application, which is the other concern that I have, is that if it's not immediately clear, and Ms. Whitney pointed this out in her rebuttal, she said, I couldn't find this 50 square metre trigger anywhere in the plan. It's because it's not in the plan. It's only by practice of this council trying to do what it has to do in terms of implementing 3.16 already through the resource consent process that people are being tripped up. And it might not be until they've actually lodged their application and then they get 92 for more information, or even Section 88 asked to turn around and come back later on. So there is a tension here between being upfront and clear around what the expectations are and setting out a consent pathway versus letting people fall into one. That's why I want to have the benefit of the conversation with the people who have submitted that these controls be introduced into the plan in this hearing to understand what their perspective is. And
Is part of the answer, you said that at a high level it's not super clear, that is that when we work through the objectives and policies, we do it with that Mr. Daish's question in our minds. Is the direction of how this would work in practice sufficiently clear? Is there a clear steer that the outside SNAs, the number one question is, well, are the effects significant? How's that going to be assessed? For instance, and if they are significant, then you're going down an effects framework, which, as Commissioner Daish points out, it may not actually work because if you're dealing with a single site. On the other hand, and this may be in the effects in the non-statutory realm, occurred to me, the council no doubt has lots of nice to have ecological improvements on its land that might provide an opportunity for compensation for off-site effects.
I noted this in my 42A report, I believe, and I identified that it was problematic that no financial contributions, I haven't put forward any financial contribution schema at this point in time, and that in the future that might be absolutely something that could be beneficial. I think it would be a good idea that, for argument's sake, say we move forward with this outside SNA control, that there's the ability for when those effects can't be offset, that they are compensated, and setting aside the problematic discussion we said about who's compensating who this morning, that there is a fund which is available for council to go and say plant the outer greenbelt and increase the extent of and representation of those SNAs which have otherwise been removed through urban development. Like, I think that's fundamentally a good idea, but it's not something we've got to do now.
When we talk compensation, we usually mean money. Compensation can be in kind. That you could have a frame where if there is enhancement work, for instance, in the town belt that wouldn't otherwise be done, it could be directly funded by a developer that needs to find some compensation, not funded, but either in cash or kind.
I agree.
And the question is whether the plan could say that. But that's just developing a thought.
Yeah, and further developing a thought. Normally with things like replacement planting when there is loss of vegetation, you would normally value replacement planting higher to where the effect is, much more than if it was remote. you had a bit of bush in Miramar and you're wanting to plant some of the out of town belt out the back of Karori, it seems to me that it doesn't really equate.
Yeah.
So it is fraught, and I don't know if there is an easy answer at this particular point in time. Yeah, the other thing is about just having a square metre areas, and you've already pointed it out, is that it doesn't recognise the value of the actual Indigenous bird biodiversity at all. It's just it's a crude standard to trigger an assessment. Not necessarily a crude standard, but a standard to trigger an assessment. And the other things which are floating through my mind and we'll talk to Dr. Goldwater or Mr. Goldwater tomorrow about it, is whether or not, the removal of potentially a lot of it would actually undermine the whole function of that area of having Indigenous biodiversity. By having even 100 square metre loss, what's it going to mean to the integrity of the Indigenous biodiversity of what remains?
Part of the answer might be that in the viewer, you made the point, Mr. McCutcheon, that a lot of the excluded SNAs were in fact extensions of public SNAs. So that might give which might answer Commissioner Dacia's concern. Well, Mr. Goldwater will tell us whether that's a good answer or not, but that might be part of that answer.
Certainly the compensation and offsetting appendices of the MPSIB point towards compensation or offsetting being undertaken in the same ecological district or within the same area is preferable.
But same ecological district means
They're massive.
like
Yeah.
in Wellington's terms, that's everything except the south coast.
Yeah. So perhaps there is some flexibility.
So the back of Karori would be within the same ecological district as Merritt, to use Commissioner Dacia's example. Do you want to pursue that any further, Lindsay?
No.
Okay. Interesting thought. I think that's ideas for us to test further when we go through the detailed provisions. So I think section 7 is just a summary of the information. Section 8 is general.
Sorry, I just have a question on your paragraph 176.
Yes.
It's just about Greater Wellington's submission. And part B talks about Appendix 8 qualitative wind study. I just wasn't sure how, are we assuming that should be Schedule 8 SNAs?
I think
Rather
that's
than-
the correct assumption. Yeah.
Yeah. Just had a deja vu back to another hearings.
So what's the change that's required?
I think it should be Schedule 8 SNAs, not Appendix 8 qualitative wind study. That's my thought.
Yeah, not obvious why wind.
Yeah.
So that is Appendix 8. There was a wind study.
Yeah. Yeah. Wind assessment.
Oh yeah. Okay, so going on, section 8. Your discussion of general submission points. you'd, and in particular, paragraph 191 about Kiwi, Capital Kiwi Trust Board. The you're sort of like an SNA creep concern, which some would see as a positive thing, since it is indicative of that your maintenance and enhancement is working. I wondered about this whole question about if people are doing positive things, do you leave them to get on with it, or do you wrap them up in regulation? To the point where they say, well, that they've had enough of trying to do the right thing and they'll look after themselves in the future. Thank you very much. That I thought, I wondered if you'd considered this issue against the background of the objective of the NPSIB, the second arm of the objective. Like, we focused a lot on the first arm, achieving it by recognising people and communities, including landowners, as stewards of Indigenous biodiversity, which seems to be what they're saying, that we're doing the right thing. You should recognise that we're doing the right thing and support us.
I agree. It's problematic. I think while there is some good recognition in that objective level, there's not much in terms of how adverse effects on SNAs are required to be managed. And the subsequent clauses, 310 in particular and 311, that give much follow through or comfort to that recognition in the objective being respected. I think perhaps one example of how the plan does recognise how landowners and communities have been stewards of Indigenous biodiversity is represented through the specific provisions for Zealandia and the continued operation of Zealandia as a permitted activity, and allowing clearance within Zealandia for them to do their thing, as it were. Over time, it might be a case where, you know, if there's some clear boundaries of the Capital Kiwi program, that, you know, similar carve-outs or recognition in the rules is integrated into the plan at that point in time. But I do share the concerns of the submitter that, you know, over time you could be perceived to have SNA creep. It might be, and this is probably a question for Mr. Goldwater, that, you know, it would take a long time, not that would be much comfort, for regenerating bush to meet the criteria to be identified as an SNA. For some types of bush it doesn't take very long, others it might take a little bit longer. And I also think the other problematic bit here is the mobile fauna criteria, which I have not proposed to address because we need regional council direction on that. But essentially what that's saying is that if birds and other creatures like to move around and they like to live in particular areas, then they automatically qualify as SNAs as well. Boiling back to my point, I think that there is the opportunity through the rule framework to recognise these efforts of very valiant efforts of communities and landowners to undertake regeneration and restoration, but that it's not fully supported within the framework of the NPS.
Is this an example of something you described earlier, where there are high-level throwaway lines that seems to have been engrafted well, this is my cynical interpretation, that have been engrafted on a document, but no one's done the check. Has this actually worked through the document like this? It's almost a PR statement.
I think to
It
some
could be read as such.
Yeah, I think to some extent that could be fair. I think like just adding another sort of angle to the Capital Kiwi situation, Mr. Norman spoke this morning to a lot of rural land being quite marginal uses anyway, and it probably won't be actively used for productive farming, or this SNA is in a gully or a valley. That might take some of the sting out of these areas being identified as SNAs, but I totally sympathise with the overriding principle that they're trying to do something good, and you could be seen as being punished by having an SNA identified on the land.
And what we should have done was roll in with a chainsaw.
Certainly, I've got those stats on certificates of compliance actually over lunchtime, and there were 25 within the last 3 years. And then 2 since the plan was notified, which probably got caught out by the SNA rules having immediate legal effect. But coming back to our question about how many, it was 25.
And they would all have been done on the basis of the draft district plan.
Yeah.
A preemptive strike, so to speak.
Yes, I would hesitate or hazard a guess to say that was the case.
Just in terms of the Capital Kiwi, in paragraph 191, you say that you recommend that this tension be considered at the next plan review. Is that because you're anticipating that Greater Wellington would have done some work in that space to, if you like, help people like Capital Kiwi who are doing, nice things, but don't want to get them caught? Is that what you're envisaging? Something happening there first, or?
Yeah, so I would be hoping that a regional biodiversity strategy would be revisiting this matter in light of these groups now being formed and operational and having good success, and potentially even changes to the NPSIB.
Yeah.
I'll ask Mr. Goldwater this question, but there are a lot of migratory birds that breed in inland Canterbury and transit to the Manukau Harbour and Firth of Thames and back. I imagine they all come through Wellington airspace, so make landfall between the islands. Is the potential for, when Greater Wellington has done its analysis, for corridors probably following the coast to be identified as SNAs for that ground, or do those migratory fauna provisions, do they need to touch ground?
Certainly in respect.
Is it the ground you're protecting or the air?
Certainly in respect of SNAs themselves, I think you'll be testing Mr. Goldwater and Dr. Anderson for a while on does something need to breed or to live fleetingly or to have a burrow.
How long does it need to live there?
And how long does it need to be there in respect of SNAs? In respect of the mobile fauna clauses, they're ones which I'm not so familiar with because I've recommended deferring them, so I didn't spend a lot of time reviewing them. But looking at that clause 320, must record areas outside SNAs that are highly mobile fauna areas. Areas used by a specific highly mobile fauna. So I guess we'd be having a debate about what used means.
They're flying through. Relevant to wind farms, but probably not anything else. the your discussion at paragraph 195. The discussion you're talking about ground truthing. Is that another problem with reinstating SNAs, that if landowners had been engaged in a process where there was clear potential for SNAs to be invited, you would have been deluged with requests, if not demands, for you to ground truth, and as indeed the MPSIB would direct, but because they're not on the process, that's not happening.
Yeah, I agree. I mean, it is right now, there may well be issues with the accuracy of the mapping on some sites, and a couple of submitters have made submission points in this stage in their speaking notes to date about where they recommend further site visits be undertaken, and certainly very open to going and doing those. I guess that's what happens in a desktop exercise, which has been necessary to undertake an evaluation at a city-wide scale, at a district scale for SNAs. I mean, that's not an uncommon way to identify SNAs in district plans. In terms of individual property owners, I mean, dating way back to 2019 when the backyard taonga process started, when those there were 1,700 odd letters went out, 1,300 of them in respect of residential sites. Only 100, I think I've got the exact number in here, I think it's around 180 site visits were requested, yet so there was an opportunity there which some people will take up and others will not. And the MPSIB recognises this as well, where in its assessment of areas that qualify, it states that a site visit is the best thing to do to, without doubt, identify and assess whether something meets the criteria and make the trimming on the mapping there. But it also recognises that sometimes entry will be refused or people don't want a site visit. So that, there may well be areas.
Yes, I was thinking that in the Parairoa plan process, we had, I think it was like 150 SNAs, and we had a large number of landowners who rocked in to want to talk about the boundaries. And we directed that the wildlands team or the council instruct wildlands to go and have a look and report back. And a large number of them changed. Like some in only minor ways, some in more significant ways. But I think that that's sort of inherent in a, as you say, a district-wide desktop exercise. It's a good starting point, but it shouldn't be the end point.
No, and I agree, and that's, I think, why we have endeavoured to respond to those submissions who asked for a site visit to come and do some, and not everyone has taken that opportunity up. I guess the other thing I've been thinking about is that if it so turns out that if a consent requirement is triggered and that assessment is found to be inaccurate, there is a consenting pathway there, albeit at a cost to the applicant. So it may well be that there is a consentable outcome, but in the first instance, it would have been preferable if the mapping had carved out areas that didn't have SNAs or vegetation that met the criteria.
The going on to 196, talking about extension. This is about the Tawa Community Board. The land rezoned from rural to residential, rural under the ODP to residential under the DP. Where are these? Where are we talking about? Like obviously in Tawa, I can figure that out.
I can report back to you on where those specific
Yeah.
sites are. I imagine they're on the peri-urban fringe in Tawa.
Yeah, if you could, thanks.
Yeah.
So we have a clearer fix. Why don't you make it 214? Mr. Norman's queried inclusion of residentially zoned SNAs would raise a question of equity. 400 landowners incur costs, so small benefit to community at large. In his view, you haven't actually said what your view is of that argument, and assuming you think it has merit, could you say the same about heritage listings? Sort of large cost to individuals for wider community benefit.
I agree that you can draw some parallels between any types of planning provisions that impose restrictions on people's property rights and the ability to undertake alterations or activities that they were otherwise able to do. I guess one of the differences between where or the system that's set up to support heritage owners and SNA, well, otherwise residential SNAs, is that there is a reasonably well established and operating Heritage Resilience and Regeneration Fund, which does provide a level of funding to owners of heritage buildings to undertake maintenance and conservation of their building, as well as earthquake strengthening on application. A number of submitters have asked for similar programs to be established for SNAs. And I've commented around how that was put forward for annual plan processes, but didn't get through the whole process. But that there's another opportunity potentially next year to raise the issue again in the context of the review of the rating policy.
Yeah, understand the point. 218, Mr. Norman's analysis that land that's currently identified as being of significant natural value is likely to be located on less productive land. Now, intuitively, you'd think that that's probably the case. But has anyone actually looked at where the SNAs are on the properties and as to whether that is borne out in fact?
Only in respect of the site visits that myself and the rest of the staff involved in this have been on, and the conversations had with owners about what their intended use of that part of the site might be, and otherwise through other aerial imagery, and looking at the relationship between slope and where that vegetation is, but not down to the level of asking an individual owner what their intentions are with a particular part of a site. I guess the other restrictions that those were problems that those people may face, particularly the relationship between steep gullies and watercourses, is how other triggers of the regional plan and freshwater instruments are kick in and place additional barriers in respect of using those areas of land productively.
In other words, SNAs may be the least of their problems. (227), talking about doc submission. Saying Schedule 8 is considered to suitably identify all non-residential SNAs. What's the basis for your confidence?
I guess the basis for my confidence is grounded back in the original Wildlands report, the 2016 mapping, and how that has evolved over the years. It's been checked when site visits have been requested by owners. The extent of those SNAs have been reviewed against the NPSIB criteria last year by Wildlands as well, and they all came back with a tick of alignment, as it were. I know. So the regional council may be aware of their submission. They identified that some SNAs were missing, but have not been able to provide the information enabling me to compare that to what's in the notified plan and what the net difference is. But if such information were made available and impacts on property owners and who those people are, brought to me, I would be more than willing to turn my mind to making some recommendations in respect to those areas, but I have not had the benefit of such information.
Well, they're fast running out of time.
Could we just go back to, 225? Where you talk about more work on a later plan change. Incentives for priority restoration. Leads me to think about non-statutory methods within the plans. And you've got one which you're recommending, is about restoration and so forth. It's very much the exception in the plan that you have a method as opposed to a rule. Had you thought about, or do you think it would be appropriate to look at expanding that to talk about these sorts of other things, which is over and above what's in that method already, which could assist in terms of council's obligations in terms of the NPSIB? Or do you think that's as far as the plan should go?
So I agree with the submitters insofar as that there is nothing in the plan at the moment, and that incentives are a useful tool to support people who have identified special values on their properties. I would be open to including another non-statutory method to do with considering incentives packages. I agree that it would add some weight to the consideration of those coming to life through a council financial planning process, and to sort of give some weight to that if it were included in the district plan. And that there's clear direction in the MPSIB that councils should consider providing these things. There's a good alignment there.
Yeah, but you can only go so far with that because you can't
Yeah.
commit the council to undertake financial expenditure.
Correct. Would be very much be down the line of
But
it.
it's more encourage, promote type
Agree.
method. Okay.
In terms of your comment at 2:30, basically encouraging anyone to get into contact, did you have any takers?
Not to me personally, though I have noted that Mr. B. Layton and Mr. D. Edmonds have made requests through their statements, and they can be actioned in time for the my writer reply. That's my.
So that was
plan.
Mr. Edmonds and Mr. Layton.
Correct.
Dolph Layton. Yeah. The this is actually I wrote this question and note to myself in relation to Horokiwi Quarries, which has been overtaken by Mr. Goldwater shifting of ground on SNAs. But what was council's attitude generally to identifying SNAs where the landowner had a consent or a certificate of compliance enabling clearance of all or part of the bush concern? How was that treated?
Back in section 4 of my 42A report, I noted that one of the considerations way back in the backyard taonga process was where a resource consent or a building consent could be provided to show that works were, to be undertaken on a part of a site that would have an SNA identified on it, or a certificate of compliance had already been granted for that site, that there were trimming out of areas back then. Of course, some of those developments may not have occurred, and an owner has, had an area trimmed out, so there's no longer SNA, that they no longer, they know they didn't undertake that development. In respect of Horokiwi Quarry, I know that there's been quite a lot of backwards and forth as to what their existing use certificate means, and I would look to Mr. Whittington to talk to how that played out during the quarry hearing. But in respect of that area, there was not any concession granted in terms of the mapping of an SNA before the notification of the plan. So the extents on Horokiwi, as I understand it, reflect the Wildlands report as of 2016. I cannot say whether any site visits occurred back then before the notification of the plan to trim areas out as it relates to Horokiwi.
The paragraph 77, or page 77 actually, It's not a paragraph. It's in the middle of your table. The speargrass weevil. I seem to recall, was it Ms. Van Haren Giles producing a big wad of material from the council's historic records about speargrass weevils. Or no, it was in Stream 8. And I wondered if you had regard to that material.
I had not, but thank you for raising that with me, and I can turn my mind to it in respect of Mr. Insol's submission.
Yes, if you could, thank you. Yes, because it was in the description of the ONL, right? SAL, I've forgotten which it is. That was where it arose. The following Insel submission about Corey Stream Estuary, and you said further research required to ascertain the presence of quite a long list of bird species in this thing. And likely at least some are present. That would suggest that on the face of it, that Mr. Insel has grounds for suggesting that some may need to be culled from the description.
Yes, so the initial advice I've had from Mr. Goldwater is that it's highly likely that some of those birds are found in that SNA as well. There's just a step to work out which ones.
I think my message would be, I think if you're saying that I think it's not likely that some will be present. That's supporting what's in the, it's the ones that are not present.
Yeah.
That which should be removed from the description, which is the important bit, because that's what would respond to the submission.
Correct.
But the implication is he's right, but he may not be completely right.
Correct.
So I think that we need further feedback from you with the benefit of Mr. Goldwater's input, because on the face of it, you're saying it needs to be changed, but you're not just quite sure how it should be changed at this minute.
Correct.
So I think we need further advice.
Just while,
Any more on Section 8? If you
was there any update from Mr. Halliday about the Lincolnshire Farm GIS files and so forth? I know he's appearing later on, but we don't have anything written from him.
I have not heard from Mr. Halliday since my rebuttal went out. I worked quite closely with him and he reviewed my draft response, so we're quite closely aligned on that. I just haven't received any shapefile from him around the extent of the already cleared bit. That would be really useful to have.
Okay, so I think the update might be that you've considered that and it's in your rebuttal, and the only question is whether Mr. Halliday comes in with additional
Yeah.
areas that need to be considered. Anything else on section 8, Lindsay?
In relation to the Boston real estate, there was going to be, I think, was it undertaken during the course of the hearing? Has that been raised or?
So this one I covered in my rebuttal in response to Mr. Delija. And I rung Mr. Delija and the landowner on the day that the 42 went out, thinking that I had missed inviting a site visit. But that offer was rejected for the reasons set out in my rebuttal.
Just further to that one. So SNA is over mixed use, and it's regardless of the residential component of that zone.
Correct.
Yeah, so it's only the residential zone that's been excluded from SNA.
Correct. The large lot residential zone, medium density and high density residential zones.
Was it ever contemplated for mixed use or not at all because of the fact that it's not a true residential zone?
It was more to do with the fact that the wording in the council resolution was quite precise in that it was talking about residentially zoned, from residential zones in terms of the family of zones within the National Planning Standard Zone Framework. And that was where the primary concerns, as I understood, of the councillors and the community lay at the time, rather than everywhere across the urban environment where residential activity was enabled.
As a matter of interest, is that particular mixed use site used for residential purposes?
I am not aware. That site had a slip come down into the side of the building a few years ago when there was, I think it was 2017, when there's a really heavy rain, and it's still got a great big hole in the side of it. I think it's been patched up. There used to be Higher Light or some sort of garden supply shop run out of it, but I'm not sure if residential activity occurs in the site.
To my knowledge, there's not. I think the property was built in the late 80s and used to have another spot zone on it before it became mixed use.
Is that everything on section 8? Right, section 9. General submissions. 250 and the discussing here the extent to which, I think this is a doc submission, would be or doc seeking give effect to the NPSFM. So 7 SNAs are described as having wetlands within them. Are there any known natural wetlands not within an SNA?
Not to my knowledge, but notwithstanding if they haven't been identified, my view is that the protections in the NPSFM and the NSFW and the regional plan are sufficient to manage those values such that the PDP does not need to intervene. the issue of what's a wetland. I don't need to exercise the point about how fraught that may be.
Discussion of definitions in your general approach. Is generally amend notified definitions to be the same as the NPSIB. Add this 280, add new definitions from the NPSIB where necessary. To me, that raises the obvious question of, well, what scope are we relying on to add a whole lot more new definitions?
So that scope I saw is within those submission seeking general implementation of the NPSIB.
Those ones you told us this morning were a bit problematic because you were giving effect to an NPSIB that didn't exist at the time.
I agree, it didn't exist at the time. I mean, one of the other points I pressed in that section, as did the reporting officer for RPS PC1, was that there's quite an alignment between that draft NPS and where the final one ended up. Not saying that that's a reason why we should take comfort in jumping to the final NPSIB, but an observation I make is that there was a degree of alignment that perhaps the notified PDP didn't align with.
How were those submissions framed? What was the actual relief they were seeking? Like, I'm not, like, just give us a couple of examples. Like, what did Forest and Bird and Doc say?
Find those. So the Director General of Conservation made a plan-wide submission saying the council should undertake a review of the NPSIB exposure draft or soon to be gazetted NPSIB document to confirm the proposed district plan is giving effect. The proposed district plan should be updated to give effect to the NPSIB where required.
So that was prospective. That wasn't talking about the draft. It was saying when the NPSIB is affected, the plan should give effect to it. So
at that time, the exposure draft was already out.
but
we agree on that.
But the more interesting point is saying it's when it's so it wasn't saying give effect to the draft. It was saying give effect to the final document when enacted.
Correct. Just checking Forest and Bird.
Well, yeah, true. But equally, you're looking for scope from a submission.
Yeah, so they didn't go to the extent of saying you need to provide 10 new definitions.
No.
Dealing with buffer, mosaics, those sorts of things.
No, they didn't go to that level of specific detail. But so the lens in which I've applied is how much can we implement that is certain, that is directive, that is necessary to interpret the provisions. And if we're in respect to those definitions, I've recommended a new avoidance policy and a new effects management hierarchy policy be included, which use those terms. And in my view, not carrying through the definition, which is expressly used in that policy, would be problematic. Of course, a consent planner could turn their mind to what that definition is in the NPS, knowing that the policy's been included for that reason, but I thought it more efficient.
But as Mr. Whittington said, although the submission can be read as saying give effect to the law, it also has the benefit of saying, well, I was going to say it has the benefit of giving scope to give effect, which wouldn't otherwise be occur. The other question might be to ask, is a submission seeking relief with reference to a document that doesn't currently exist, so therefore no one can know for sure what is in it, a valid submission? Yeah.
And available, but it does feel more of a
Dodgy.
information.
So, yeah. So, I asked you, how did Forest and Bird approach it?
So I just turn my mind to the regional council submission. In respect of Appendix 3, just in particular, they've said that this approach would align with that taken in the NRP and the MPSIB exposure draft. So they have commented specifically on one appendix and trying to align it directly. Forest and Bird said, Forest and Bird said it is not acceptable to wait for the proposed national policy statement on Indigenous biodiversity to come into force before meeting the requirements of the Act, is what they've said. There is no guarantee that will occur. Leaving this is in respect of residential SNAs, leaving SNAs without protection in the meantime risks the values of those areas being lost. Then they also talk about a point directly in respect of the outside SNA framework and requesting that
So they're not adding to this discussion. They're not adding support to utilising the NPSIB. They're saying you should do some things anyway, irrespective.
Correct.
But notwithstanding discussion Mr. Whittington and I have had, on the face of it, doc submission does give scope. Okay, which was my original question. So we'll note that and move on. There are only another 140 odd pages of your 42A report to go. Yes, that's probably a good idea. He's doing all the hard yards. Okay, good plan. We will break and restart at 3:35. Okay, we'll resume hearing and commissioners, any questions on definitions? That was the balance of section 10.
I just had a question about the definition for restoration. Just your paragraph 272 to 277. I'm conscious that restoration got removed from the plan. And I just wonder that it's not going to somehow cross over back into that historic heritage by, putting back in the, obviously the definition is different, but you're not going to run into a problem, if you like, with the historic heritage.
I think one way we could mitigate that problem would be by clarifying that the definition is for the purpose of the eco chapter. The term is used in the heritage chapter.
Exactly.
The other thing we can do is it's quite easy in the e-plan to just turn off the hyperlinking of a definition where it's not the relevant one. So we could do that and make it for the purpose of the eco chapter.
Yeah. Okay. No, that's good. Thank you.
I think we should, I think definitely needs for the purpose of the eco chapter.
Yeah.
And if you do it with the hyperlink as well, that would be helpful, but okay, anything on section 11? I'm at 323. Any advance on 323? Paragraph 323. Oh no, don't need that. We've answered, discussed that. So I'm up to the national policy statement section, so 344. Those, or actually 349. Mr. McCutcheon, you expressing concern. Well, this in the following paragraph, saying I can accept the directive requirements with respect to avoiding significant adverse effects on SNAs. Was 310, and I looked 310, and it doesn't seem to talk about significant effects. Seems to be any effects.
Yeah, correct. That's an error. It should have said a wide range of effects.
And then because the nature of the exceptions isn't effects-based, it's more activity-based. Exceptions to the NPSIB rules.
Correct, yeah, and 311. And the ones stemming from clause 3.15 specified activities.
The your description in 352 saying, is it the need to create a well-functioning urban environment that's subverted, or the scope to meet the development needs? Because this comes back to the point of, well, if Indigenous biodiversity is part of a well-functioning urban environment, it's hard to see how as you say, managing minor adverse effects on Indigenous biodiversity it's not managed as an SNA could subvert.
I can see that in light of UFDO 7 saying that ecological sensitivity is part of creating well-functioning urban environment, that the wording that you offered would be more appropriate.
I'm just having a look at UFDO 7. Oh, the reference you're referring to is in being ecologically sensitive. Is that the hook?
Yes.
Different wording though, isn't it?
Yeah,
For your new Eco 02?
yeah, so new Eco 02 is only in respect of the outside SNA Indigenous biodiversity. I think what I'm drawing a connection to is that the amalgam of Indigenous biodiversity provisions in the plan have been recognised as contributing to creating a well-functioning urban environment, and by being ecologically sensitive at a more generic level, as the strategic directions are typically pitched.
Yeah.
And to fill that gap of what this means in reconciling IB with UD, Eco 02 directs what that approach should be for outside SNA Indigenous biodiversity, where that tension has been left unresolved.
In terms of that wording, again, if Indigenous biodiversity is part of the well-functioning urban environment, we need to play with the words sort of recognises the need to create, talk about more about consistency with, because there are a whole lot of specified elements of a well functioning urban environment that are the things you don't want to sort of throw the baby out with the bathwater type scenario. And if biodiversity is part of that urban environment, is argument that the whole thing's circular.
Mm.
Well, it does recognise, because
Yeah.
what you really mean is consistent with the specified elements.
Mm.
Something like that.
Yeah, I can see how that wording's more focused on and reconciles more than just recognizing that there's a conflict, but directing that something be done about it and how that should be done, which is in a consistent manner.
And the main, but also that it's the specified elements, because the issue is that because policy 1 is inclusive, it's an open question as to how many other elements there are of a well-functioning urban environment. And so, you'd have a lot more precision if you focus that on the specified elements, which are clearly with the starter, which is what the NPS is really focused on. But that's something for you to think about. The just further up on 354, saying consider not one, shouldn't be a one tree out, one tree in, is another way of looking at that, to focus on the policy 8 wording. So that's what you're doing is maintaining Indigenous biodiversity. You're not maintaining every plant, every tree.
Certainly, I agree. I think that assessment should be at a city scale. We've talked about New Zealand scale, but I think a city scale is a more appropriate scale at which to set that aspiration, rather than a site-by-site basis, which just cannot be achieved.
Now, you said a key element is to focus, is to apply a minimise adverse effects approach. Now, as Commissioner Daish observed, minimise is defined, but only in respect of only in respect of natural hazards. Does that if minimise is going to be the centrepiece of your policy direction, do you need to define what you mean, particularly given the discussion I had this morning with Mr. Whittington about how do you make sense of the effects framework?
And this was something
in the middle of it.
Yeah, and this was something that Miss Whitney picked up on as well. She had taken the interpretation that Commissioner Daish had picked up. I think my intent was that it not be so directive, so as to require all those effects to be minimised as far as practicable. And the reason I considered that was because I didn't think it was appropriate that effects on unidentified Indigenous biodiversity hadn't otherwise been identified as significant, and the effects themselves, which are being created by the development, are not significant either. They're just other adverse effects, should be required to be minimised as far as practicable or as reasonable. My intention was that it be more along the lines of the reduce interpretation of minimise, and in that light, swapping the word out for reduce or defining minimise differently.
Well, in an RMA context, the the synonym of choice for reduce is mitigate.
Yeah, which is Miss Whitney's approach, which I'm open to as well.
And like, I suppose where I started was, if you're going to use minimize, do you need to define what you mean?
Mm.
And I think what you're telling me is maybe you don't want to use minimized.
Mm.
So I think that that's something for you to ponder. It's a difficult question because there are many moving parts. So I think that that's a matter for reply. I think the next point I had was 358. And this is the trigger you adopted. And it's in the second half of that paragraph. Accordingly, it's reasonable to assume that areas of greatest significance have already been identified in the plan and subject to notified eco rules. Well, it would have been, except for the fact that all the SNAs were pulled.
Mm. Yeah.
Right. Not sure you can, it is accordingly. So the question is, what do you do about that? That this comes back to the point you've discussed earlier, that not all pieces of Indigenous bush are equal. Some are of higher quality than others, and it's not necessarily just a function of size.
No.
And that, well, you say you've reflected on a 50 square metre range and come up with 100. And I thought that was rather it was interesting, given that, as I recall, Forest and Bird suggested 200.
Mm. So the 100 square metres was the threshold for which Mr. Goldwater was comfortable with.
So that's
Yeah.
so that's the source. I was going to finally get around to a question. I was musing there for a while.
And yeah, so Mr. Goldwater recommended the 100 and the 3,000 square metre triggers in his evidence, which was released at the same time as this 42A. Forest and Bird did, yes, suggest a 200 on a 12-month basis, I believe it was. The reason I discounted that was because, I mean, we've talked about how fraught measuring and monitoring vegetation clearance controls are. That my view was that even a time-bound one would be more difficult to measure and monitor as well, such that sort of a point in time you can remove this much up until this threshold would be more effective from a monitoring perspective, notwithstanding the issues that the control has in and of itself.
Is like, I was going to ask you about that. Do you have then, like, I understand the problems of specifying an area over a period of time, but if you don't specify an area of time, are you inviting, oh, we'll clear 100 this week. We'll be back in 2 weeks' time to clear another 100.
Mm.
And then 2 weeks after that, we'll clear another 100.
The intention with the rule is that it would capture instances where people are removing vegetation for a particular purpose, for building a residential unit or for doing development rather than wanting to incrementally eat away. I mean, there is the possibility that someone takes out 99 square meters from the date that the rule commences and wouldn't need resource consent. The intention is if they took out 101 instead of that 99, then they would require resource consent. So it's from the intention is that from the date that the rule takes effect, that's your limit for how much you can remove on that site as part of a contiguous area.
So so there is a time limit. It's perpetual. It's it's from notification, well, from the plan decisions.
Yeah.
It's 100, and as soon as you click over more than 100 compared with what it was whenever it'll be a date in 2025, you need a consent.
And the reason that it's that contiguous area rather than just a clump over here, here, and here, is to capture those scenarios when someone wants to purposefully go and remove vegetation to build a unit or to do a development. And I can see how you could come to the conclusion that that's a big loophole in it, that you can just you could eat away and you could take out 10 square meters here, 10 square meters here, over here and over here, and collectively they equal 100, but they're not being captured by the rule. But the advice that I'm acting upon in that is the advice from Mr. Goldwater that it's those contiguous area, those groups of, or the big areas of vegetation which are being removed, which contribute to ecosystem functioning by virtue of being up against another SNA or up against an SNA or have collective mass that they support that ecosystem is the type of removal that we should be concerned with.
Just a clarification. Is it per title or is it that is per title?
Yes, per
Yeah.
lot. Yeah, on a site. So there's a relationship with lot. Yeah, title.
Okay. I know you often talk about site and activity site, and it doesn't always mean title.
Yeah.
That's why I'm just clarifying that. Thank you.
The alternative would have been making it the removal of vegetation totaling 100 square meters in its entirety, no matter whether it was a bit here or here or here or there. But in my view, that didn't seem an efficient or effective thing to do to address the tension of urban development versus and NPSIB and reconciling them. People are unlikely to go and do that just for fun. People, the work that Mr. Norman has provided and that I expand upon in my rebuttal says that people appreciate this stuff. They're not going to go and remove it willy-nilly unless they've got a reason that they should remove it, which is to do a development or because in some cases they're worried that they're going to have additional restrictions placed on them.
Or yes, issue of interpretation. You skate in and out of the tree rules. In the Act 76(4)A to 4D. Do we need a definition of what a tree is? I think I read somewhere else in your report you cite a dictionary definition, but the question is, are you recommending we insert a definition of tree? Do you think it's necessary, the way the rules are structured?
Yeah, so my research and my rebuttal showed that there were some plans that did define tree. So Christchurch did for the purpose of their IPI, but that was dispensed with by a recommendation of its independent hearings panel. There was no definition in the unitary plan. So to some extent, it is curious how tree has never been defined in the RMA, nor any national direction. and hasn't in a number of plans. It has in the Lower Hutt City District Plan, which would be the definition I would recommend aligning with, which is based on a 3 meters in height trigger, or alternatively a diameter at 1.4 meters. Now, this definition would be necessary to clarify for people at what height a tree is a tree, or otherwise it is indigenous vegetation, which would be captured by the rules. To some extent, I think it's one of those things where you know it when you see it. To use
Yeah, we know where that came from.
Term, but I can see how a definition would be useful.
Yeah, and it's only in relation to indigenous trees, isn't it?
Correct.
So your pine tree or your Norfolk pine. But I also seem to recall reading somewhere, and it might have been Mr. Goldwater, who talks about there is value in some non-indigenous trees as well in terms of habitat and biodiversity as well. So if you've got a really good oak tree, for example, and you got a really scruffy Purakawa tree which aren't native to Wellington, you can cut down the really good oak tree potentially, but you can't do anything with the scruffy Purakawa tree without consent.
Yeah, and part of it, provided it's under 3 meters on a residential site. Yeah, and the reason why is because 3.16 is only in relation to indigenous biodiversity, not biodiversity more generally, which is accepted as within the context of an SNA, usually being a mix of things all considered. I would find it perverse if this provision were to apply to exotic trees under the guise of, Yeah,
I can understand that.
I suppose I'm looking at your rules, and for who, which is the urban zone version, permitted a tree is being trimmed, pruned, or removed. I would suggest you need to define what a tree is.
in my rebuttal, I identified in response to Ms. Whitney that the words indigenous should be.
Yeah. So I think so. You are I haven't turned up your rebuttal. Obviously I've read it, but you're recommending a definition aligned with Lower Hutt.
Yes, I have not included a definition in my rebuttal for clarity, but I do recommend that a definition, the Lower Hutt one, be included in the plan.
Well, in that case, request is in your reply, can you give us words that you recommend?
Certainly.
The (392) recommending 3,000 square metres general rural open space and recreation Wellington town belt. and then 100 square meters on all other zones. This also is something I think you addressed rebuttal in response to Ms. Whitney's submissions for the quarry, which suggests that there are zones other than general rural open space and recreation and Wellington town belt that are not intrinsically urban, and do they need to have a separate limit that's defined to the nature of the zone? The quarry zone is an obvious example.
In Miss Whitney's evidence, my reading of it was that while she raised concerns with the idea of this control, she didn't advocate for a quarry to be added into the same rule step as those other zones. So notwithstanding there may be merit in that, I did recommend increasing the level of permitted clearance in respect of SNAs from 2.5 to 5 metres to allow for the continued maintenance and operation. Her 3,000 metre trigger was in respect of the permitted clearance of an SNA within the quarry zone. So yeah, in her evidence, my reading is that she wasn't so much commenting on this Eco R4 rule, so much as the SNA permitted clearance.
Yeah, so yeah, I think you're right, because her concern is with the part sections 17 and 18 that the quarry zone sought in stream 6 to be rezoned to quarry that is currently rural and is currently covered in bush, which is also an SNA.
Correct.
So so you're right that it's a separate issue for this point. I'll work my way around to understand the point. Thank you. In terms of the wording of the rule, set out at paragraph 403. I wondered about the focus on whether the indigenous vegetation existed, which is in turn a question of, well, how old are the plants that are there? And whether a better question might be whether the area was one of indigenous vegetation as at, and whether they're the same shrubs or the seedlings from those shrubs or whatever else is in there, then would go by the board. And you could go off your aerial photos in terms of enforcement. So how does that strike you as a concept? Because I just thought, while you can get an arborist, an ecologist to tell you how old the trees are, there's going to be a cost to that. And if you're not actually talking trees, you're talking about 500 shrubs of various kinds, it's going to be a massive exercise.
You would start the rule being an area of indigenous biodiversity existed at the date. And that would enable the use of aerial imagery more clearly.
I think it would.
Yeah.
I think it's
Yeah.
the same concept. I don't think Mr. McCutcheon knew that the typical
Plants themselves.
was vegetation that existed as a date of the council decision. I think you
In the ground. Yeah.
But that's what somebody would argue.
Yeah. No.
The only issue with the area is because, of course, this is outside a significant natural area. Significant
Well-
areas that might be a little confusing.
Or the spatial, we'll call it the spatial area.
Yeah.
Next question. D2, should this be referencing public roads, rail corridors that are both infrastructure? Isn't that what the INF and the infrastructure eco subchapters for?
Yeah, correct. I agree. It would be useful to separate the issues with the infrastructure from other uses in its entirety. I think from memory, my logic was to include that just as a belts and braces to make it abundantly clear. But in hindsight, it probably confuses matters because the intention has been to keep the INF Eco chapter completely separate.
Because this was a discussion we had in the
Yeah.
infrastructure hearing. Having made that call, carved them out of the other chapters, other chapter rules, to avoid arguments about which rule applies.
I think it might be beneficial if to retain the private driveways.
I agree with that.
Ways.
The private access driveways, rights of way.
Yeah.
That are not infrastructure.
And similarly with the flood protection.
Yes.
I don't know where the infrastructure hearing got to on whether flood protection was infrastructure, but.
Well, we certainly had a long discussion about whether seawalls were infrastructure. And I think the answer might be, well, it depends what they're protecting.
Yeah. Do they form part of another piece of infrastructure?
Yes. Because I think Ms. Dewar's argument, which persuaded Mr. Anderson, was those seawalls are protecting the road before they protect the airport, and they form part of the road. So that's something else for you to think about. So to tell you the truth, I can't, Commissioner's question, I can't recall where we landed with flood protection works. I think we concluded there weren't any. There isn't any in Wellington City. There aren't any stop banks.
And I guess like I'm turning my mind to sort of the drainage, the stormwater scheme in upper Stebbing or lower Stebbing, Glenside, Churton Park, sort of area that Mr. Halliday is talking about, that probably falls within the definition of a water supply distribution, a drainage system, drainage or sewage system, potentially.
Yes, but that's natural hazard controls are a different matter.
Yeah.
So
We have to stay, I mean.
So not sure about that. Thank you for you to ponder, give us some advice about, please. This may be because it's come straight out of the NPS, but I wondered about in sub 0.6, whether imminent is too restrictive. If you have
It's there because it comes straight from the Eco R1 equivalent. I think it would be a bit over the top in respect of outside SNA Indigenous biodiversity. I would just have to check submission scope in respect of the Eco R1 equivalent, because I think it would be desirable that they were both the same.
because typically you think it's sort of like the discussion you have in the right to die legislation. Somebody's terminal, but the medics can't say it's going to be the next 6 months, whereas like a tree might be dying over a lengthy period and be dangerous, but not imminently dangerous.
And this was a similar sort of matter we addressed in the notable tree hearing as well, with respect to terminal
That's
decline.
exactly
Yeah.
what, and I think we landed in the notable tree hearing on
Removing it.
on serious danger rather than imminent threat.
Sounds familiar. Let me just check.
Yeah, but you're right. We had the same discussion in relation to notable trees. We removed it.
Serious and imminent.
Serious and imminent. Wow.
We up the ante.
There you are. Double wrapping.
But the terminal decline bit removed on the advice of Mr. He had a short name. We can picture him. Jez Partridge.
Yes, I was going to say partridge.
Yeah. That trees can be in a terminal decline, or there can be arguments as to whether they're in terminal decline or not, and on that basis it was removed.
There might be in terminal decline, but be good for another 100 years, sort of thing.
And Plimmer's tree was the example.
Okay, so maybe if that was consistency with the notable trees would suggest that we should be thinking about the same language. If the scope. And then 10, given you're using the date of council decisions for the vegetation, why is the retirement unit at plan notification? Shouldn't you use the same trigger for both?
Sorry, which clause is this?
Sub clause 10 or X.
Oh, fire break.
Fire breaks.
Oh, right. Yes. Agree. It's a hangover from the notification.
And is there a reason why the same provision, fire breaks, is not in the all other zone rule?
I think that was because that fire break is only located in the rural zone for Eco R1. And it was carried in it to reflect that carryover. I didn't put it into the all other zones, just the general rural, but I can see that there would be merit. My only concern point to note would be that would potentially allow quite a significant amount of removal. Not that the other clauses don't already, but
I suppose
there might be, yeah. The fire break one's interesting because FENS submitted on that as well, in that compliance with section 43 or 64 of the FENS Act is when they tell people to go and cut stuff down because there's a fire going on or they need to cut stuff down themselves. That imminent threat and imminent threat one, I recommended be amended just for the purpose of clarity. That included for fire safety. There's also the ability to for the maintenance of existing buildings that was added in, to get, in my example, to get scaffolding up and around buildings.
yeah, well,
There may well be merit.
I think the fire break is more significant, as we've discussed endlessly, in response to KiwiRail's request for maintenance buffering. Scaffolding doesn't actually require that, whereas a fire break, FENS recommend 10 metres of flammable clearance of anything flammable from the wall of I'm not sure if it's a dwelling or a building, but like clearly FENS saying, well, this is what we would require. But should the plan provide for landowners to be concerned about their own property?
I think if people were, they would have already cleared it.
Yes, it's quite interesting.
I mean, it's not a thought that comes to my mind with the bushes directly outside my lounge, but
Around here.
Do that.
I know other plans generally only applies to rural
yeah,
land. No, the Canterbury plans all consistent on that, but it's all rural. And I think it's more than 10 metres down there too.
yeah.
But yes, we had the same discussion in Haurua, where you've got Kanuka right up to people's windows, which will go off like a bomb given half a chance. So I think there are conflicting, I think bouncing around here, but there are pros and cons, and I wonder if you could, in reply, you could advise us the pros and cons of adding a fire break and where you have landed and why. Typo for you to check, Mr. McCutcheon. Page 126. The cross-reference to in 2C, I think should be R4 2B. I'm not sure whether it's just that version or whether it's correct, and it's correct. I didn't check against your appendix.
Yes, that is a typo. It should be R4.
We're going to, Commissioners, we're going to break at 4:30, which is now in 3 minutes time. My next question is on the introduction. I don't want to start into that because that's the detail of the wording. Has anyone got anything before then?
Just
You've got 3 minutes.
No
no
pressure.
pressure. Just, so your paragraph 412, which looks at your new provisions that you've got in there. Just for eco objective 1, you're talking about Wellington City, and for policy 1, you're talking about Wellington District. I just wonder, are they intentionally different? Should they be the same?
They're not intentionally different and they could be the same.
It just would make,
Mm.
I think, sense if, I don't know which one's better, but they should be the same. Thank you.
Wellington Ecological District, which is being referred to.
That wasn't my intention. It was just supposed to refer to the area to which the Wellington City Council has jurisdiction.
Okay, and say any more before paragraph or section 11(3) starts? Which is on page 132.
And
On that case, we'll adjourn. Well done, Mr. McCutcheon, going well.
Thank you.
And we will return at 9 AM tomorrow. Do you hear Mr. Goldwater first?